attention. Good afternoon, folks. We're going to start the 1 p.m. or thereabouts docket for the January 14th, 2020 version of the BMZA. Initially, we ask that you please turn off all your cell phones, keep talking to a minimum. Obviously, the proceedings are being recorded by audio and by video as well. If you have to have a discussion, we ask that you step out into the hallway to do so. The board will vote on each case and make a decision at the end of the docket, unless you've otherwise been advised for some particular specialized reason. But you're certainly welcome to stay at the conclusion of the docket to be here for the deliberations. Otherwise, you can call the BMZA office tomorrow morning after 9 a.m. That number is 410-396-4301. Again, that's 410-396-4301. In any event, you should receive your resolution in the mail within 30 days. Please do not do any work until your resolution is received, and of course, do not do any work in Baltimore City without pulling the proper permits. I'm going to start with cases for which postponements are being requested. We just call those matters and have the parties appear to, handle that postponement request. Case number 2018-349, 598 West Patapsco Avenue. 2019-349, 598 West Patapsco Avenue. Good afternoon, Mr. Woolman. This is this appeal is to use portions of premises for temporary storage of used and damaged automobiles, so on and so forth.
So on and so forth. Yes.
You are here to request a postponement?
Yes. Actually spoke with Mr. French and emailed your staff earlier this week. We have a meeting with planning on Friday to address some issues that they've raised. We then extended our contract to purchase the property, so for that reason we need a postponement today, please.
Very well. Any questions or objections from the board?
No.
Okay, so granted, sir.
Thank you.
Thank you. The case of 2019-384, 3507 Edmondson Avenue. Gregory Bennett.
Mr. Chairman, Mr. Bennett or someone speaking on his behalf requested a postponement. They may or may not be here today, but the board has the authority to postpone if it sees fit.
Very well. Any objection from the board with regard to that matter?
No objection.
So that one will be formally postponed. Calling the case of 2019-439, 1611 Guilford Avenue, Guilford Brewing.
Abraham Hurdle on behalf of 1611 Guilford Avenue. With me is James Hudick.
Hi, Herbert Burgunder on behalf of Guilford Avenue LLC, one of the neighbors, and with me is Louis Linden on behalf of Guilford Avenue.
Okay, and we understand that is the applicant that's seeking a postponement today?
That's correct. We're working on MOU with the community. There's been some neighbors who I guess may not have been as involved in that process as we wanted as well, and we're going to be working with them too. Our target ideally is 3 to 4 weeks out.
And Mr. Hurdle, you're aware this property is in a PUD,
I am.
and that PUD has restrictive language that might prohibit the use that you're requesting?
I am aware of that, yes.
And then no MOU can cure that particular problem?
My client and I have discussed this, and we are working on MOU with the community.
As long as you understand. Thanks, sir.
Yes.
Very well. Any questions from the board or any objection to the postponement request?
No objection.
Okay, so granted. Thank you, gentlemen.
Thank you.
Okay, I believe that does it for the postponements. Going to turn our attention to the consent docket. These are cases for which the board has concluded we have sufficient information to grant your request. When I call your case number, if you could line up to my left, first case here, next one following it, all the way down to my left. We will have all of the parties and witnesses sworn in, and then we'll call your case individually and deal with the particular matter. If you would come up in the order the cases are called. Case number 2019-421, 1802 Jackson Street, John Bolster. Okay. Case number 2019-426, 1301 West Old Cold Spring Lane, Leisure Row.
She was here.
Case number 2019-427, 1835 Walbrook Avenue, Antoine Newton. Folks might miss their opportunity.
That particular applicant had either called or someone sent in a message that he may have some transportation issues, so the board can call that later if the chairman would like.
Okay, that's 427. I'll recall that. Any word on 2019-421, 1802 Jackson Street? We receive any information on that?
None that I'm aware of.
Case number 2019-431, 452 North Patterson Park Avenue, Zainab Bushra. Case number 2019-443, 2424 East Fayette Street, Vladimir Velov. Case number 2019-444, 701 South Glover Street, Adam Carballo. 2019-445, 5 South Broadway, Betty Fouché. 2019-448, 28 Pulteney Street, Martin Christensen. Okay. That's all for the consent so far. Could we have all these parties sworn?
Can everybody raise their right hand? Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make be the truth, the whole truth, and nothing but the truth?
I do.
Showing that everyone said in the affirmative, yes.
Thank you. Calling the case of 2019 do it again, 421, 1802 Jackson Street, John Bolster. All right, moving on. Case number 2019-426, 1301 West Old Cold Spring Lane, Leisure Row. Good afternoon, Mr. Rowe. This is a request to use as 2 dwelling units?
That's correct.
Okay. Do we have any staff reports?
Thank you. Yes. Martin French for the Baltimore City Planning Department. Planning Department has reviewed this application and recommends approval. Thank you.
Thank you. Mr. Rose, anything you'd like to add?
Yes, I went to the liquor board because there was some question on some of the staff reports regarding the liquor license, and I did get some information that there was a transfer of liquor license, and there is no tavern or liquor license being used at this property. So I wanted to submit this
Very
for
well.
the new ownership. Thank you very much.
All right. Pass that on down. Anything else?
Thank you.
For the board having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you very
Thank
much.
you. Have a great
good
day.
Thank you.
Case number 2019-427, 1835 Walbrook Avenue. Antoine Newton. Still
Maybe
nobody
late in
here?
arriving.
Oh, that's the one we got it. Moving on from him. 2019-431, 452 North Patterson Park Avenue. Zainab Bushra?
Yes.
Okay. This is a request, Ms. Bushra, to use the ground floor as a grocery store, is that correct?
Yes.
Okay. Do we have any staff reports?
Planning Department has reviewed this application and has no objection. Thank you.
Ms. Bushra, is there anything you'd like to add to your appeal?
No.
Okay. Well, the board having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much. Case number 2019-443, 2424 East Fayette Street, Vladimir Velov.
Yes.
Mr. Velov? Okay, good afternoon, sir. This is a request to use premises as 2 dwelling units?
Yes.
Okay. Do we have any staff reports?
Planning Department has reviewed this application and has no objection. Thank you.
Okay. Mr. Velov, is there anything you'd like to add to your application?
No.
The board having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you.
Thank you.
And again, I will receive the letter in 30 days, as you said.
I believe that's correct? Yes, sir.
Continue, like, okay. Thank you very much.
Case number 2019-444, 701 South Glover Street. Mr. Carballo, good afternoon.
Hello.
This is a request to construct a second-floor rear addition with a rooftop deck. Is that correct?
Correct.
Okay. Do we have any staff reports?
Planning Department has no comment on this application. Thank you.
Mr. Carballo, is there anything you'd like to add to your application?
No, sir.
All right. Well, the board, having heard your appeal, believe we have sufficient information to approve your appeal.
Thank you.
Thank you. 2019-445, 5 South Broadway. Ms. Betty Fouché.
That's correct.
All right. Ms. Fouché, this is a request to construct a second-floor rear addition and use premises as 5 dwelling units. Is that correct?
That's correct.
Do we have any staff reports?
Yes, Planning Department reviewed this application, noted that this property is located in the Washington Hill Historic District. Therefore, any additions or alterations to the structure on the exterior will require approval from the Commission for Historical and Architectural Preservation. The department recommends that approval of the application be subject to the condition that all exterior changes, including additions, demolitions, and alterations, are completed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
Ms. Fouché, are those conditions acceptable to you?
Yes, they are, and I had already filed with CHAPS long before filing here. And that was already accepted, and it's listed on the front window of the building.
Very well. Is there anything else you'd like to add to your application?
No.
All right. Well, the board, having heard your appeal, believe you have sufficient information to approve your appeal. Thank you.
Thank you.
Finally, case number 2019-448, 28 Pulteney Street, Martin Christensen.
Yes.
Mr. Christensen, this is a request to construct a new third floor with a rear deck. Is that correct?
Yes, sir.
Okay. Do we have any staff reports?
Planning Department has no comment on this application. Thank you.
Sir, is there anything you'd like to add to your application?
No, but you say 30 days. Is it possible to find out the results sooner? And
Oh, well, this result, I think you'll know in T-minus
Oh,
2 or 3 seconds.
I'm not going to get permit sooner than 30-day letter. That's all.
Okay. I don't know.
The consent agenda cases typically go out 2 to 3 days after the hearing. So the 30-day window is required by code. So we have up to 30 days, but the most go out much sooner than 30 days.
Excellent. Perfect.
And to round out the record, Mr. Christensen, the board, having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you very much.
Thank you, sir. Okay. Let me just try these 2 consent matters, or at least one, again. 2019-421, 1802 Jackson Street, John Bolster. Going once, going twice. Gone, sold, whatever. All right. Now we'll turn to our regular docket. Let me just ask this to the folks that are out in the room. To the extent you are here on a case for which either you are the opposition or for which you know there is opposition that has been lodged to your appeal, but you have not had an opportunity to speak or address the opposing party, could you stand and state your number if that is the case? Very well. Okay, calling the case of 2019-409, 1332 Delwood Avenue. Joseph Bright.
Yes, sir.
All right, sir. Mr. Bright, this is a request to use the premises as 2 dwelling units. Is that correct?
To continue to use it, yes.
Okay. Could we swear the witness, please?
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes, it will.
State your full name for the record.
Joseph Paul Bright III, otherwise known as Jay.
Right, Jay. Do we have any staff reports?
Yes, Planning Department has reviewed this application, noted that this property was last authorized for use as a single-family dwelling. However, this property is located in R6 zoning district, where conversion of a single-family dwelling to a multifamily dwelling is not authorized. The department therefore recommends disapproval of the application because the zoning code does not authorize conversion of a single-family dwelling to a multifamily dwelling in the R6 zoning district where the property is located. Thank you.
Okay, Mr. Bright.
Yes, sir.
Tell us about your project, and I guess in particular, the evidence of its use or prior use as a multi-family dwelling unit to be used.
Okay, I guess first I'll deal with the fact that there are 2 meters in the property for both gas and electric. And the electric meter was installed in 1987.
And what's the basis of your information that it was installed in 1987?
My son, Matthew Bright, is a master electrician, and he looked at it and stated that it was installed on that date based upon what is the information on the meter.
Okay. Now, there are two meters. Which meter,
That's the electric meter.
okay, the electric meter.
I have no information as where when the two gas meters were installed. I don't know how Baltimore Gas and Electric works. All I know is they've been installed there for some time. I imagine they were legally installed, and the property has always been used as 2 units. In
What
a
is the basis?
continuing.
Let me stop you. Do you own the property?
Yes, I do, sir.
How long have you owned the property?
Since December 21st, 2004.
Okay. And were these 2 meters, gas and electric meters, there since 2004?
Oh, yeah.
What else can you tell us about the property?
Well, I guess the other pictures I took for you are, the pictures showing the entrances to the building. There's 4 separate exterior entrances to the building. The building was built in 1872. It's the largest building on the block.
Do you live there?
Presently, I have a work week occupancy on the top floor. Yes.
What does that
Which is, that means that my wife owns a house in Arnold, and on the weekends, I'm home with her. During the week, we both have jobs in the city, and during the week, we occupy that top floor.
And the bottom floor, is that rented out?
Bottom 2 floors is not presently rented out.
And since you've owned it since 2004, when during that time have you had both the top and bottom floor being occupied?
Almost continuously.
When was the last time the bottom floor was occupied?
October.
Of 2019?
Yes, sir.
And Mr. Bright, you had filed an affidavit signed by the prior property owner. It should be in the board's packet as well, stating that the prior owner had owned it from 2001 until 2003 as a 2-dwelling unit building. And then Mr. Sherwood, the prior owner, attests in his affidavit that he purchased it as a 2-family unit when he purchased the property in 1979.
Okay.
Is that correct?
Yeah.
Okay.
It's 3 floors, but 2 units, correct?
Yes, ma'am. The top floor is a 2-bedroom, 1-bath unit, and the bottom 2 floors are 3 bedrooms, 1 bath.
Okay. Any additional questions from the board? Mr. Bright, is there anything else you'd like to add?
Well, you have a picture in your file that was taken by staff, I imagine. The picture shows 2 buildings there. The one in the foreground is actually the building next door. That's 1334 Delwood. That is a 3-unit non-conforming property. And in the background in that picture is my building, 1332 Delwood, which I'm seeking to continue as 2 units.
Okay. Don't know what photo you're referring to. Do you have the photo that?
It's in the
Chairman.
Okay.
Sad photo.
It's in
This one here, sir?
Yes, that's the one. The building in the foreground is not my building. It's 1334. Minus in the background, yes, sir.
Okay.
And the other building
Yeah.
is a 3-unit, and I'm seeking to continue mine as a 2-unit.
Okay.
Very well. All right, nothing further from the board. Thank you for your presentation.
Thank you.
I'm going to do this one more time since it's here. For the last time, 2019-421, 1802 Jackson Street, John Bolster. Silence. All right. Moving on to case number 2019-432, 1167 Carroll Street. Adam Carballo,
Which one is it?
421.
428.
Oh, I'm sorry.
There was consent.
We'll switch those.
We're going 32 before 28.
Yeah, for now,
Okay.
he's here.
Okay.
All right, 1167 Carroll Street. Mr. Caballo, this is a request to construct a second floor rear addition and use premises as 3 dwelling units. Is that correct?
Yes, sir. Just to elaborate, it's actually a second floor infill addition.
Second floor infill addition.
Correct.
Okay.
So that addition would only be on the second floor, to replicate the first floor footprint.
All right. Could we swear the witness, please?
You swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
State your name.
Adam Carballo.
Do we have any staff reports?
Yes, Planning Department has reviewed this application, noted that this property is in an R8 zoning district. The recorded use of the property in the historic record included a corner store on the first floor level of the premises, last authorized to be a carry-out food shop, and then a single-family dwelling above. The application proposes 3 dwelling units in this property, which would require a lot area variance of 40%, which the Planning Department considers to be excessive. The department is therefore recommending disapproval of the application because the amount and proportion of lot area variance needed for approval is excessive in relation to the amount required by the zoning code. The department would have no objection to approval of 2 dwelling units at this location. Thank you.
Okay. Mr. Carballo, with planning's observations in mind, tell us about your project.
Sure. As Mr. French mentioned, this is a corner property previously used as a commercial carryout on the first floor with a single dwelling unit on the second floor. This particular property has 3 entry doors on the property, 1 at the corner, 2 along the West Osteen Street side. My client wishes to basically utilize all 3 of those existing entry door locations to provide 1 dwelling unit per door. We've actually presented this to Pigtown Main Street. They are actually in support of this property. I have a letter, several copies of a letter
Certainly hand those up.
from Main Streeters
All right.
that would be in support of that change of use. The building is full lot coverage, and again, we would like to have a second floor infill addition to basically maximize the site. As you can see from the side, basically proposing an addition just above this existing first floor, just at the rear of the property. This building is one of very few buildings that is full lot coverage on this block, so it's a pretty sizable building in comparison to some of the other buildings along Carroll Street. Carroll Street's kind of a narrow street, so we feel like the lot size sort of lends itself to having that density, and Pigtown Main Streets, as well as residents that we've reached out to, are in support of this change.
Okay. Are there any other communities or community associations that this particular property either borders or otherwise impacts, if you know?
I don't believe so, but this is the group that we presented to.
And Mr. Carballo, what is the resulting size of each dwelling unit under your plans?
Let me see if I. Sorry, let me add this up in my head. They're each going to be approximately 600 to 700 square feet apiece, but we're proposing basically one bedroom units, so they're generous for one bedrooms.
Your plans have 2 rooms, 2-bedroom units for all 3 rooms, all.
Well, some are,
One of them goes down to the basement and the other 2 go up to the 2nd floor.
right. Well, the one on the 2nd floor, if you see, there is a 1-bedroom and then the living room at the rear, 1 bedroom and a living room at the back. And then on the ground floor, sorry, two bedrooms on the upper floor and then a single bedroom. The one at the rear is a 2-bedroom, sorry.
Any additional questions from the board?
Nope.
Is there anything you'd like to add, Mr. Carballo?
No, I think so.
Very well. Thank you for your presentation, sir. Good luck. Okay, thanks. Call the case again of 2019-427, 1835 Walbrook Avenue, Antoine Newton. Mr. Newton? You Mr. Newton?
No, he is.
Okay, step in front of the microphone if you wouldn't mind. Thank you. Mr. Newton, this is a request to use the rear portion known as 1919 North Monroe Street as an office for tag and title service. Is that correct?
Yes, sir.
Okay. Could you swear the witness, please? And the witnesses.
Do you swear or affirm under, can you raise your right hand? Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
And can you state your name?
Davon Newton.
Do we have any staff reports for this matter?
Yes, Planning Department has reviewed this application and has no objection. Thank you.
Okay. Mr. Newton, is there anything you'd like to add to your application?
No, sir.
All right. Will the board, having heard your appeal, believe we have sufficient information to approve your appeal?
Reverend Bailey, can I say something? Reverend Bailey, President of Fulton Heights Community Association.
Yes, sir.
Under the umbrella Greater Mondawmin Coordinating Council. We are glad to accept them to have the business there. The only problem we have had with the trash, but they have worked with the community association to straighten that problem out. So I have nothing against it.
Very well. Thank you for your addition,
Thank
sir. So I think that concludes it, Mr. Newton. Let me say it again, just so the record's clear. The board, having heard your appeal, believe we have sufficient information to approve your appeal.
Thank you, sir.
Thank you. All right. So he's good, he's good. That one, maybe not. Calling the case of 2019-428, 3009 Poplar Terrace, Derek Shaw.
I like your instincts. Hello.
Hi.
Hi.
Mr. Shaw, this is a request to use the premises 2 dwelling units.
To continue to use it as 2 dwelling units.
Okay. Can we swear the witness, please?
Can you raise your right hand? Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
I affirm.
And state your name, please.
Derek Shaw.
Okay, do we have any staff reports for 2019-428?
Yes, the planning department has reviewed this application. Information available to the department indicated the property was last authorized for use as a single-family attached dwelling. The property is located in the R6 zoning district, which does not authorize conversion of single-family dwellings to multifamily dwellings. The department therefore recommends disapproval of the application because the board is not authorized to approve conversion of a single-family dwelling to a multifamily dwelling in the R8 zoning district where the property is located. Thank you.
Okay, Mr. Shaw, can you tell us about your project and in particular, what information you can provide?
Well, I bought the property as a foreclosed property, and it was already sanctioned as, it has 2 electric, I provided copies to the zoning office, the meters and the gas and electric meters, so it was already like that upon acquisition.
Okay?
And I think that's there, the meters.
When you bought it, were there 2 people?
No, it was vacant,
It
because
was
it was a
vacant?
foreclosed.
Okay.
So it was already vacant, so I just put the called BG&E and just got services within my name. The only reason I didn't know it was a zone, because the tenant on the first floor is trying to get Comcast, and she can't get Comcast because it's not 2 units. But she's living there, and I provided her income. She gave me her Social Security and her BG&E bill.
Okay, so when you purchased a property, these 2 meters were already in the present?
Separate entrances, separate
Separate,
mailbox,
everything.
numbered.
Yeah, everything was, the place, I thought it was zoned. I didn't know until she told me.
Okay. All right. Let's see. Okay.
That's her Social Security statement.
I would just recommend in the future, if someone gives you their social security statement
Mhm.
and it has their social security number on it.
I don't think it was, is it on
That-
there?
I
Oh.
would just black it out.
Oh, okay. No problem.
Do you happen to know how long the property had been utilized as a 2-dwelling unit?
Because I own a house adjacent, right next door to it. That's how come I knew it was a foreclosure. So I knew the previous tenants that was there before it got foreclosed upon, because I own a house at 3011 too. And that's a single-family dwelling.
How long have you lived at 3011?
No, I'm a landlord.
Oh, okay. How long have you owned that house?
I own that house, about 8 years now.
So the entire 8-year period, there were 2 separate units?
Yeah, it was 2 tenants in there, but I was conversing with them, and then ultimately, I saw the sign posted it was foreclosed. So my knowledge was that it was already 2 units.
All right.
How long have you owned this property?
Oh, probably about 4 years or something like that.
And in that 4 years, you've always had 2 separate tenants in it?
No, it was vacant. Well, I owned it for 4 years. It took me a little while to fix it up and stuff like that. So when I'm up, it's up to standard now. So it was vacant, then now it's occupied. We realized what was going on.
Okay. Okay. Any other questions from the board? No.
Nope.
Okay.
Thank you all.
Thank you, Mr. Shaw. Now,
Save this one.
yeah, why don't we do that, because we're moving really well. Let me call the case of 2019-437. 3819 through 3821 Bank Street. Ms. Hertzmark?
Hello.
Good afternoon. This is a request to consolidate 3819 through 3821 Bank Street. SS.
There's 4 different lots that we're going to be consolidating, and one of them is a city-owned parcel that doesn't have an address. It's an 8-foot wide parcel for utilities, so that's probably where you're getting
Yeah,
confused.
well, I'm just reading. What
Yeah.
SS.
It's referring to this small little piece.
Right. 276 east of Eaton Street, 3905 through 3915 Bank Street, and 3904 through 3906 Eastern Avenue to construct a 5-story multiple-family dwelling with 149 dwelling units, 115 off-street parking spaces, and 8-foot, 6-inch high wall. Is that correct?
Yes.
Okay. We swear the parties, please?
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
Do we have any staff reports?
Yes, first we have a letter from the Highlandtown Community Association dated October 18th, 2019. They indicate that they have been presented with the design proposal and are supportive of the project.
Planning Department.
What did they say? Highlandtown?
They support it.
They're supporting the project.
Planning Department has reviewed this application, noted that this property is located, this site is located in the Highlandtown Business Area Urban Renewal Area. For that reason, there will be a required design review of the proposed structure. The proposed structure must be approved by the Urban Design and Architecture Advisory Panel. The department therefore recommends that approval of the application be subject to the condition that all construction and improvements are completed in accordance with plans approved by the Department of Planning. Thank you.
Thank you, Mr. French. Ms. Hertzmark, should we be favorably disposed towards your application? Are those conditions acceptable to your client?
Yes.
Okay, tell us about your project.
Thank you. So the application is to construct a 5-story, 149-unit multifamily dwelling. The site is split zoned. IMU 1 is the portion facing Bank Street, and then there's a finger that connects the site to Eastern Avenue. The Eastern Avenue portion is C1. The entirety of the building development will be in the IMU 1 district. The site is just over an acre in area, and it's in the Highlandtown neighborhood, and as Martin mentioned, in the Highlandtown Business Area Urban Renewal Plan. So the site is, it's south of Bank Street, north of Eastern, and a little bit to the west of Grundy Street. The existing building is an unoccupied warehouse, and the surrounding zoning is R8 across the street on Bank, and to the east of the property, C1 along the Eastern Avenue corridor, and I1 to the northeast corner. So the proposed multifamily dwelling will have a parking garage with 109 parking spaces, as well as 6 surface spaces for a total of 115 parking spaces. So the requested relief that we are here for today, the first one is for lot area. The lot area supports 147 units. We are requesting 149. And the main reason is that's, you know, that can fit in the building. It's a 5-story building. The second, third, fourth, and fifth floors are all the same, you know, with dwelling units. Many of the dwelling units are studios, and 53 of them are actually less than 500 square feet. So there's a market need in this area for these smaller studios, which is why we felt appropriate to have 149 units in lieu of the 147 permitted here. The next variance that we are requesting is an interior side yard. This is one where the requirement is 0 or 10. And the way that the property lines fall is that they're not exactly at a 90-degree angle. So at one place, the building's in line with one property line, and it doesn't exactly follow the next one because the angles are off. So, you know, it's a 0.7-foot setback on that side. So it's not quite 0, but it's obviously with the intention that it's built to line. And then there's an interesting thing with the property lines where Benefit Street coming from the west ends at the property. And at that point, there's a 7.5-foot jog in the property line. So the interior side there is 8 feet. And that's a unique situation just because of how the property is oddly shaped. The next variance we're requesting is the wall height in the interior side yard of 8.5 feet in lieu of the 6 feet. That's the maximum permitted. And you should note that that's just for a small portion. If you see on the site plan where it indicates there's a blast wall that's 8.5 feet high. That's on the east side of the property. That's for the BGE transformer. Based on the existing utilities and proposed utilities on the site and BGE requirements for clearances and means of access, that was the only place to put the BGE transformer on the site. And so because of that location, that blast wall is required for security based on BGE standards. So it has to be 8.5 feet tall, and that's the variance we're requesting there. And then finally, we're requesting a variance for parking of 115 parking spaces provided in lieu of the 123 required. Now, I know I said there are 149 dwelling units. 53 of them are studios that are less than 500 square feet. So the parking requirement for those is 1 per 2. And then there are 96 dwelling units with a 1 per 1. We actually are providing 49 bike parking spaces. So once you factor in the motor vehicle parking offset, the parking requirement drops from 123 down to 119. So we're providing 115 in lieu of the 119, which is a 3% variance. As I mentioned, a lot of these apartments are studios, and the developer anticipates that they're going to be rented by young professionals working at nearby large employers. The parking spaces will be rented for $125 per month, so there should be some amount of self-selecting there of who's paying for that additional fee for the parking in the parking garage. It should be noted that this is not anywhere near any restricted permit parking areas. There is street parking available on Bank Street. And notably, on the south side of Bank Street, we're actually going to be reducing the number and length of curb cuts, which basically opens up a little bit more parking on our side of the street. We're also going to be increasing the street trees and the residential scale street light poles and regrading and replacing that concrete sidewalk. So all of those will serve to make the south side of Bank Street a pleasant area for parking to serve this development. Also notably, there's a development coming in at the northeast corner of Bank and Grundy Street at 4000 Bank Street, which is a proposed parking lot. And that parking lot is going to be for short-term public use, so which could be used by visitors to this development. Also monthly for local residents and also valet. So that should serve to satisfy some of the parking needs in this area. There are also existing bus routes on Eastern Avenue. There are 3 different buses that go there, and there are stops at Eastern and Grundy, Eastern and Eaton, which is the street just to the west of the development, and Eastern and South Haven, which is another street over to the east. So in general, it's an infill city lot with a unique shape. There are existing utilities on site which provide some constraints as to exactly where the building and the walls and everything need to be developed. And as the Highlandtown Community Association said in their letter, they feel that this is an upgrade to the neighborhood and will remove an old eyesore warehouse and replace it with something that really adds value to the neighborhood. So we feel that the variances are necessary to make this project viable.
Okay. Anything else you'd like to add with your contingent? Any questions from the board?
I'm good.
No questions.
All right. Thank you so much for your presentation. Good luck to you.
Finish these up and go to the cluster at the end.
Case number 2019-440, 501 Sanford Place, Edward Grant. Good afternoon, Mr. Grant.
Good afternoon. How are you?
I'm doing well, thank you. This is a request to use the premises as offices, is that correct?
Yes, sir.
Okay. Could you swear the parties, please?
Right hand. Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
Do you have any staff reports?
Yes, we have a letter from Councilman Leon Pinkett indicating that he provides support for the Stanford Place project to be rezoned for commercial space. That is the end of staff report.
Planning Department reviewed this application, noted this property is zoned R8. The last recorded use of the property, according to the record that was available to the department, was a single-family dwelling with an accessory home daycare center. The question before the board, therefore, is whether the building itself qualifies for use as a neighborhood commercial establishment. The department has no objection to the application if the applicant provides the board with information concerning previous lawful use of the premises for a non-residential or commercial purpose. Because neighborhood commercial establishment uses are limited to the reuse of an existing building that is non-residential in its construction and original use, or that has received prior approval for a non-residential use as evidenced by permits, construction, or historical evidence of lawful non-residential use in what are now residential or office residential zoning districts. The building did not appear to qualify for consideration for the proposed use, but the applicant may have additional information that would show that the building could be used as proposed. Thank you.
Thank you, Mr. French.
And Mr. Chairman, we also have a letter in support from the Druid Heights Community Development Corporation as well.
Thank you, Mr. Baumgartner. Mr. Grant, tell us about your project, and in deference to the commentary from Mr. French, Department of Planning, the history of the use of this particular building.
Well, I have that.
Tell me what it is you're showing me, sir.
So this is the permit for the daycare that they pulled on October the 7th, 1998.
Okay, so to operate a daycare in the home?
Yes.
Is that for 6 or less children?
It was for 8 children.
Okay.
It says premises as a single-family home and daycare for not more than 8 children for part of 24-hour day.
Okay.
That's correct.
I'm going to open this up to Mr. Baumgartner.
Sure.
With regard to the use of a property as a home daycare versus a daycare facility, one, is there such a distinction made?
There is. I believe the magic number is 8. A home daycare can have a maximum of 8 children. A home daycare being defined as someone's home property that they use a space in the building for a state of Maryland licensed daycare, home daycare. The difference between a home daycare and a daycare facility or a daycare center is the number of children. So more than 8 would be considered a daycare center. I don't know the state regulations on whether or not that can be a live-in property or not, but the prior use sounds as if it was a properly licensed home daycare.
Okay.
And what does the code speak to, if any, with regard to whether a home daycare with 8 children or less is a residential use or a commercial use?
So the code does not speak to that. It is silent as to that question. In an R8 zoning district, a property to be eligible for a neighborhood commercial establishment has to have either a prior lawful use or some indication that it was used for non-residential purposes. So that's the language in the code. It would be for the board to determine if a home daycare is a non-residential use or if a home daycare is a residential use. If the board determines that a home daycare is a residential use, the property would not be qualified as a neighborhood commercial establishment, and something like the requested office would not be allowed. If the board, however, decides that a home daycare is a non-residential use, the property would qualify as a neighborhood commercial establishment, and it would simply be a conditional use to use the property as an office.
Okay, very well. Thank you, Mr. Baumgartner.
Did you purchase this property from the daycare operator?
Well, I purchased it from the dad, yes.
The dad?
Yes. So her name is Mozilla James. His name is Vernon Thomas.
And did they live there while they were running that daycare, if you know?
It was a single family. Yes, I just purchased it maybe October.
So it was their house while they lived there and operated the daycare there?
Yes.
Okay. And what you had on, one second, and what you had on your phone was for 8 children?
Yes.
And that's starting in what year?
1998.
Okay.
You wanted to speak, sir?
I'll wait, though.
No, you go ahead and state your name and
I'm Anthony Presley. I'm Executive Director at Druid Heights Community Development Corporation.
Yes.
And we're kind of revitalizing that entire community. On the other corner is a beauty shop. And I remember the James family who had the daycare. The Mr. Grant is not planning to bring even as much traffic because it's just an office. He lives in the community. He had people working around the city, and he kind of drives around to pay them. So all he would be opening up is an office in the community, and I personally went out into the community to see if there would be any opposition, because I advocate for the community, and if there were, I would not be here. So I spoke to the neighbors, and they're liking this idea because he's going to bring more lighting. He's going to help keep the community clean. We now have a foot patrol officer there, so it's a perfect fit into what we're planning to do with that part of the community. There's a beauty salon called Liz Beauty Salon. It's the oldest business on Pennsylvania Avenue on the other corner. And then on this corner will be his office space, which has kind of a weird shape because it's the front of the building and then it leans, kind of slants. So the community's excited about it. And when the daycare was there, they ran a nice business, but they had a little more traffic because they had people dropping off children and picking up children.
So it was noticeably different than any other residence on the street.
Right, and the community appreciated it. It was a safe place. You could take your child. She did have up to 8 children in there.
Yes, sir.
But, you know, what will happen now is more lighting, more security, more, you know, less traffic, but it'll fit into what's going on. We just built a total of 6 new homes down the street, Bakersview, and they're connected to the 17 we built 2 years ago. So there are 23 new homes in the community, and it all kind of fits into the community's master plan. So I'm here to just really speak to that, how Mr. Grant has hired men from the community, and I think for the young boys in the community to be able to look up and see, Mr. Grant lives down McCullough Street. He has a business in the community. That's encouraging these young boys to stay on the straight and narrow. He's employed some of them. We're building the Gold Street Park, 2 blocks down from this, $100,000 from the city to build this park. Mr. Grant is doing that project. So he's noted in the community for leading young men especially into the right direction. So I think having this business there fits into the community's master plan, and I went door to door to make sure that they're okay with it.
Thank you, sir.
Yes.
Mr. That's what I was about to ask. Mr. Grant, would the building just be an office, or would you rent out the living space that seems to be on the upper
It
section?
would just be office space, so it's 3 bedrooms upstairs. It would just be 3 offices. Not a lot of traffic, so it's just offices with computers, so I can do bids. If it's a rainy day like today, have my guys come and they still can get paid for the day. Just maybe clean the office or things of that nature. I'm not gonna have heavy equipment or anything.
What's the nature of your business, sir?
I'm a general contractor.
Is it Baltimore contract?
Yeah.
Any additional questions?
No.
Anything you'd like to add, sir?
Yes, so I'm just trying to tighten that corner up. I will add additional lighting on the front, side, and back of the property. Also cameras, and I'm just going to try to keep that section clean right there.
Will you, is it your intent to place anything out in front of the premises evidencing that it's a business operating there?
Well, what I did want to just put my logo on the side of the building and have some gooseneck lighting above it to shine on it at night because you can see it from North Avenue. So not much, I just wanted to just paint my mural on the side, my logo.
Okay. All right. Okay, if there's nothing else, thank you for your presentation, sir.
All right, thank you.
Good luck to you. Calling the case of 2019-441, 3705 4th Street. Gail Dingle. I'm sorry?
There's 7 children.
Well, they're 6 and a half.
There's rules for 6, there's rules for 8 and 7. Why is that not?
Right. Ms. Dingle, good afternoon. This is a request to construct a 2-story rear addition and a new 3rd floor with rooftop deck. Okay. And we have,
Becky Witt on behalf of Action Baybrook, which is the community association.
are you here in support or opposition?
In opposition.
Okay.
And we were not aware of that until now.
Did you have an opportunity to speak?
We've spoken many times, yeah. Or I would say twice or 3 times.
We've met at their office to discuss our project with them.
No.
Huh. Okay.
Okay.
Who you're representing again?
Action Baybrook. which covers Brooklyn, the neighborhood of Brooklyn.
Gotcha. Okay, can we swear the parties, please?
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes. Do we have any staff reports?
Planning Department has no comment on this application. Thank you.
Okay. Who's going to lead off?
I'm Mr.
I
Dingle.
want to hear from Ms. Witt first. Why are you opposing? Because I think I understand what they're asking. I'm curious
Sure.
what the opposition is.
Yeah, so I have been working with Action Baybrook in dealing with a nuisance at this property for, I guess, maybe more than 6 months.
This specific property is a
This
nuisance?
specific property.
Is it a foot traffic or a?
It's a vacant property. It's been, it's had a vacant building notice on it for quite some, I think, a year, I believe, or more. And it's been the site of a lot of people who are homeless, spend time on the porch, sometimes inside the property. There's been drug use inside and outside. It's kind of, because it's been vacant, it's just been, there's been a lot of uses of that property.
Are there new owners to the property?
Yes.
Okay.
Yeah, so we've reached out, and I don't have my notes in front of me because I didn't know this case was on the docket until this afternoon, which is when I just called my client to talk to her about it.
Okay.
So we reached out a long time ago to talk about the fact that the property was a nuisance, and so we're very much in support of the renovation of the property. It's just the expansion up and out that is a concern.
Why is it a concern?
Sure. So,
Just ask, are you planning to reside in the property?
No, it's actually going to be a rental property.
Rental, okay,
It's currently a two-dwelling unit.
okay.
So mainly it's because it's not in keeping with the surrounding properties in terms of the height and that addition in the back. And again, I'm proffering on behalf of my client, so I can't testify as a resident of Brooklyn. I don't live there. I just work with the community association and have spoken with them just today about whether or not they were in favor of the variance, and they said that they were not because of.
Is it the yellow one?
It's a yellow house or the light blue?
Yellow, yes.
Okay. And the building next to the yellow house, what is that? That big brick?
Church.
It's a church.
And it occupies about almost 100% of its footprint.
To a church?
Yeah, well, the church
Odd place for people
runs.
to be causing a nuisance.
The church runs an outreach center,
I
so
used to own the house.
They used to own the house?
Yes.
Okay.
that's part of the reason why there is a lot of activity there.
Just for the benefit of the court reporter, if we can speak one at a time.
Do you want to add anything else for now?
Not for right now.
Okay.
Thank you.
You referenced that you were representing Action Baybrook,
Mhm.
and then you referred to your client as she.
Mhm.
President? Or
The president of the board and the CEO, yeah.
Do either of the three of you know who owns the blue house next to the yellow house, the one that's attached?
Yes.
Is that vacant also, or
It's
is
a
it?
rental. No, there's tenants there.
And are they in opposition of the proposed?
I have not spoken with them.
No, they're not. We spoke with them just recently,
Okay.
They were saying they would like to
and
do this.
they even allowed us to.
Okay, hold on. Again, we still have to have this one person talking. Sir, could you state your name?
Tony Dingle.
Okay, Mr. Dingle. I thought that was the answer, but just need to identify you for the record. Why don't you go ahead and proceed and tell us about this project?
Well, my wife actually purchased the property, and in the process, there were some issues going on with the purchase, and during a period of time, we were delayed in getting into it. In the meantime, Action Baybrook or someone called BG&E and had the meters removed, and thus the vandalization started. And property started to be vandalized. And so we've gone to the property several times to secure it. I put new windows in, new door in. It was subsequently broken. And so we don't want to continue to lose financially. This is really not for a super financial gain. This is simply, we looked around the neighborhood, and there are several boarded up homes and burnt out homes. And what we're proposing would be actually an elevation to the neighborhood. The church next door, they have an outreach program, and part of it in working at the house a couple of days, because we had a permit to change the windows twice, and I would notice some people come out of there because they do an outreach to persons who are high on drugs and other issues, and there's a terrible prostitution issue on that street.
Okay.
And so we feel that the quicker we can get in there, it wouldn't be a financial burden to us, and it will elevate the neighborhood, because now you will have a property that is actually fixed up better with tenants inside, and therefore it would cut down on transit traffic. Because I've noticed persons come out of the church and then try to get into the house. And I've made we've contact with the local police that patrol the area, and we have their cards so we can call them. So we put up security cameras in the meantime so we can actually monitor the property. So we get alerts on my phone every time someone goes by to try to cut down, and we will call the police if necessary.
Okay, so let me ask you, you're here for several variances for lot coverage, interior side yard, and the corner variance. Do all of those variances impact the church?
None at all.
Well, to what area, to what direction?
The variance is in the rear yard. The lot itself is 14 by 100.
Yes, sir.
The current footprint is 14 by 60. Our neighbor with their deck, theirs is 14 by 70. And so we want to go 14 by 75 and go up. And so it will not encroach in any way upon anyone else's property.
Okay. So again, the property owner on which your addition and construction would impact most would be the immediate neighbor.
Yes, and we spoke to them. They have no problem whatsoever.
Are you
Are
trying to make it 3 units? It's 2 now, right?
It's 2 units. Currently, the lower unit is about 850 square feet. The upper unit is about 700 square feet. And so with the proposed unit, the lower unit will be about 1,000 square feet, and the upper unit will be a 2-level unit, which would be about 1,800 square feet.
So, one of the variances that you're requesting is a lot coverage variance.
Yes.
And in an R6 zoning district, the maximum lot coverage is 45% of the lot.
Yes.
The existing building, as it sits right now, already exceeds that amount.
Yes.
So my question is, why not fix up what you got, go up to the height that's allowed by right?
Well,
what burden does that present to you?
It does not propose a burden to us. And matter of fact, when we came here today, we were willing to hear that if, with the recent adoption of that code, that it would not be extended, then we've already spoke to the planning board, and we know that the 3rd floor addition is within the 35-foot limit, and therefore we will be well within that, and we're fine with that.
As well as if the deck, if we can.
With the rooftop deck, they already preliminarily improved that. You can speak.
I just wanted to.
Excuse me, you said your neighbor approves of this?
Yes.
Do you have any written statement?
No, sorry. I'm the one who spoke to the neighbor. When she pulled up the landlord, she just said, "Oh, you guys are doing a really good job," because they just newly renovated their home, and that's why when she pulled it up, she was actually looking at the older rendition of it. He's completely renovated and is very beautiful inside, so he was very happy to know that we're now renovating the home. We have been, but the point is that she was excited and said, "Oh, we would like to do that too. Maybe we can do it together." So I was happy to hear that. My question that I just wanted, or statement I wanted to make was, he has a deck in the back, and so even if I couldn't get the 15 feet, could I stay parallel to where he's has the extension of the deck? Because right now the kitchen is, what is it, 8 feet out. It's a very small, teeny kitchen, and if I got just enough so that I could extend the kitchen on it, then I would be fine with that. And there's a kitchen right above it, the same thing.
Okay. But we don't know what that length necessarily is.
How many feet is the deck, do you think? You would probably have to submit new plans.
Their deck is roughly 10 feet out from the rear of our property. So that's what I said, their total footprint is roughly 14 by 70 currently with the deck.
So an application can always be amended down, meaning you're requesting less relief than you had originally requested. But in order for the board to consider that, we'd have to have those plans. So we'd have to be able to see them and then make any kind of computations that are necessary.
Well, since we've secured financing that is contingent on some things, I would, with my wife's approval, propose that we leave the footprint as is and go up with the current footprint as it exists so that we can move forward. And I don't really see where Action Baybrook would have any opposition, since what we're doing is actually have already impacted crime in the neighborhood. Several young people have walked by and said, "Oh, you guys have secured this place. We used to come over here and do drugs on the corner or do drugs on the porch. But now that you secured it, we have to go somewhere else." And so by their own testimony, we've improved the neighborhood.
Surprising that people are saying things like that out loud.
Well, when they hide, they
That
say
surprised
what's
me as
true.
Well, I guess the question then is, what variances would they then be seeking?
Right.
At this point, there would be none if you change it to, if we ever use existing footprints, then we need no variance.
But can I submit it late? I just wanna know.
Well, I'm not sure.
I would like to be able to at some point submit it though, even if this means that we can just go ahead and move forward with what, because we are on a long time restraint for our mortgage to be able to get through. So if we could do that for now, for the sake of time, I'm happy with that, with maybe in the future resubmitting something that would allow us to extend the kitchen.
So in the R6 zoning district, building heights are maxed out at 35 feet.
Yes.
And that is allowed by right. There's no board review. It's simply a permit. The only small little turn would be the interior side yard. Currently, the code has a mistake in it with multifamily dwellings in residential districts. But for the height portion, that is allowed by right. So you, certainly, it is your proposal, it is your application. Certainly, the neighborhood can, has the right to oppose things, but that height is allowed by right. So you're certainly, welcome to apply for a permit with new plans showing that height that would not need a variance from this board.
So is what they do with this proposal withdraw it or postpone it?
That is up to the applicant. You can
think
withdraw
what
if you withdraw, it is a formal withdrawal. So if there was any need to come back, you'd have to refile, and then there's a new posting requirement, et cetera, et cetera. You can also postpone and then do whatever you're interested in doing, and then we hold cases for 12 months that are postponed, and then we administratively dismiss them. So that would be up to the applicant.
So I think the best thing to be to withdraw it, because other than the extension, we're already within the code and we'll be okay. And you can come back later if you want to try to extend it to put in for a separate variance.
So am I to understand, because I'm looking at my husband, I don't want this to be a marital spat in between the company. So,
I saw you.
Twice.
yes.
I saw you look up, I was like, uh-oh.
Your look on
Yes. So to make sure that I'm perfectly clear, what you're saying is the postponing would be up to 12 months, and it would not necessarily mean that if I declined at this time that I can't come back and put it in, even though I have an opportunity up to 12 months to do it now for the postponement.
I think that's correct.
That I have an opportunity now to have it postponed for the 12 months, but not revisit it
That's
later.
correct.
That's why I would rather have the postponement for the 12 months.
Okay, or however long you need to postpone it.
Yes, to wherever
Up to
I
12
need to,
months.
yes.
So I'm confused. Are you still asking for the third floor?
They get that.
They
by
get
right.
that.
Yes,
by
we
right.
get that by,
35 feet. So that 8-foot kitchen that you have would be an 8-foot kitchen that you're refurbishing or
Yes.
redoing, so
Yes.
you understand that.
Yeah,
Okay?
yeah.
so the postponement would not affect if we would put in a permit to go ahead and go up. Because
That's correct.
That's
Yeah.
correct.
Right,
Okay.
'cause
It would be a
we don't
separate
hear
application.
permits.
Separate application.
Yeah.
Okay.
We're happy.
So you have a postponement request.
Yes.
Any objection from the board to the postponement request?
Nope.
Nope.
Okay, thank you so much.
And I would defer to you, but of course. the
I don't have
objection-
an objection to the postponement, thank you.
Very well, the case is postponed. Good luck to you.
Thank you so much.
Yeah, good luck.
That was interesting.
That really was.
Okay. Let me be sure here. Is there anyone in the room who is here for a case other than 2019-433, 2019-434, 2019-435, and 2019-449? You here for a case other than that? 427, sir. Ah,
Oh, great.
No, these are the rest of mine.
sorry.
He said 420.
427, 2019-427, 1835 Walbrook Avenue. Aha,
That was approved by.
Antoine, well, we
We heard that one.
We heard it.
for consent,
Mhm.
and it's granted.
Granted.
Okay, you're late to the party, but the good news is it was consent and it was
But he's
approved.
not Antoine.
It was approved?
Can I?
Well, who are
what's
you?
your name? Because I'm like, that's not Antoine.
My name's Michael Stefanos. I'm an investigator with the Motor Vehicle Administration. The hearing on the wall says it's set for 3 p.m.
Let's see here.
You would operate the tag and title?
We would license the operation of the tag and title.
Okay, would you have been here at 1 if you knew it was at 1, in opposition or in support of the application?
I would wanted to question the owner because we have a lot of questions as to his business practice.
Okay. I think you have to take that up with the owner at this
True.
point.
However, if that is an accurate photograph of the public posting, which I do not doubt, that is an improper posting with an improper time.
I can give you, this is the email chain, came from the Western District Police Department, that the hearing is set for 3 p.m.
Yes. Major John McGann, CIB, Criminal Investigations Bureau.
So the board, by its own decision, can reconsider
Yep.
its own decisions. So, Mr. Chairman, I would recommend that the board reconsider for a posting problem, a posting issue. We will reach out to the applicant to reschedule him for a hearing, and sir, you are welcome to attend that hearing or reach out to him, however.
I wanted to get a hold of Mr. Newton to make sure it was the same man we are wanting to
Checking out.
have a discussion with. I'll just leave it at that.
And I would, once you may hear from this office regarding.
Is
the
there any
date.
way I can leave my name and address and phone number, and you guys can,
I'd be happy to forward it along.
please, I would love that.
We will do that. So I guess formally, can we do this on the record? just Right now?
Yep.
Before the board is the question of reconsideration for case number 2019-427, 1835 Walbrook Avenue. The applicant is Antoine Newton. He presented here on a consent docket. However, there was a posting, a formal posting, that appears to say 3 p.m., which is incorrect. And there's some additional business to hear about that matter, so we're going to reconsider that matter. I guess we will, well, the paperwork will follow, however we need to do that formally. Thanks for your perseverance, sir.
I thought I was going to be early.
Yeah, and to a degree, you were. Let him do that. And then,
Explain later.
It's been hanging on the wall about 2 weeks.
all right. There we go. Okay. So now we will turn our attention to case number 2019. There's a series of cases. One is a negative appeal that is intertwined with those cases. We're going to call that negative appeal now. Case number 2019-449, 1200 South Haven Street, Gunther Bottle LLC.
We need to hear the of the first,
Back here doing the same thing. No, that's gonna be last. That one's 165. This is the one where, oh, I got big graphs.
49.
It's the whole nine.
Pictures. So, it should be the last thing in your little packet.
Oh, I got it.
Big Google. What did I write down about that? Negative appeal. Oh. Oh, the challenge and let me get some water, because
We will. Yeah, bless you.
Oh, 3 o'clock. I was like, something is not right here.
Gotcha.
And
Lies.
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 Who needs to break it? Yes. You also need a break at 3 o'clock. Right, remind me of that.
So funny. A lot of folks in this kitchen. More papers. Thank you so much.
Sure. I'm ready.
Oh, that's,
Oh, God.
this is water in here too.
Sure. Prove it. And then pour me some. Right.
Pour me a shot of that water. Right. Gotcha.
Oh, okay.
I think it's all the same thing.
These are all the same? Yeah.
Okay. Folks, before we get started, just to let you know, for an administrative reason, we have to take a break shortly before 3 p.m., and then we will get right back on the record and continue. Yeah. So. Good?
That's the last case, right? 449 or whatever. Don't do negatives.
Okay, okay.
That's just the clarification.
Okay, these guys know that?
Yeah. She doesn't, but I'll tell her.
All right. Okay, again, calling the case 2019-449, 1200 South Haven Street, Gunther Bottle LLC. Is a request to appeal the issuance of permit number COM 2019-03318, issued on September 30th, 2019, which states partial permit, subject to all conditions of agreement on file for footers, foundations, underground utilities, slab on grade, podium for a residential multifamily dwelling, pending action on application for plan number 2019-1479, the issuance of the general permit, and the understanding that the engineer/architect will comply with Baltimore City Building and Fire-related Code 2015. Okay. For Gunther Bottle LLC, we have,
Good afternoon, Kevin Penhaligon, Nelson Mullins on behalf of Gunther Bottle LLC.
okay, welcome, sir.
Thank you.
And the additional folks you have with you?
Rick Deal, Gunther Bottle.
Good afternoon, sir.
Buzz Obrecht.
All right, Mr. Obrecht, thank you. And we have in opposition to this negative appeal, Ms. Hecker.
Yes, Caroline Hecker, Rosenberg, Martin Greenberg, on behalf of the applicant for the permit. I'm joined by Mr. Saperstein, the principal of the applicant, John Kraft, our engineer with Kimley Horn, Scott Slauson, who's also with the developer, and my colleague Justin Williams is here as well.
Very well. Let's get all the parties sworn, please.
Raise your right hands. Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, Mr. Penhaligon, I think we can start with you. The floor is yours.
Yes, thank you.
I'm sorry?
Is there anything in the file? Your full plan or whatever?
Oh, gee, yeah. Here's a question. Mr. I want to see if there are any staff reports for this particular matter.
Planning Department has no comment on this particular appeal.
Sitting this
Thank
one
you.
out, are you?
And, Mr. Chairman, we have several letters from both of the parties in front of the board, and they can explain that correspondence themselves during their testimony. In addition, we have a letter from the Brewers Hill Neighbors, Inc., the local neighborhood association. They are in support of the project.
Support of what project?
Well, I should say, for the negative appeal, there's no comment, but for the 4 positive appeals, they are in support, so we'll hold off on that until the 4 positive appeals for the other 2 letters.
Okay.
You know what? Should I just identify all of the matters at this point? Let me do this. We called one case, which was negative appeal, case number 2019-449 for 1200 South Haven Street, but formally we'll also call case numbers 2019-433, 1200 South Haven Street and 3850 Boston Street. Case number 2019-434, 3800 through 3824 Boston Street. And case number 2019-435, 3900 through 3902 Boston Street. And 2019-436, 3904 through 3920 Boston Street. We recognize that those are the positive appeals. However, initially we're hearing the negative appeal with the case number so stated, 2019-449. And so we can proceed, sir.
Okay. Thank you, Mr. Chairperson. And initially, I would just like to introduce some additional evidence into the record, in addition to the letters that you already have. The letters that you already have in the record, there's an October 10, 2019, and if you need additional copies of these, I have them.
Thank you.
October 10, 2019.
Yes.
So October 16, 2019. A letter from November 27, 2019. Letter from December 13, 2019.
Alrighty. Oh, yeah, we have more. We'll, if they come down, I think we can pass them back up to the opposition.
Additional letter from December 13, 2019 from Rosenberg, Martin, Greenberg.
I probably have that one.
You've heard of them?
Letter from December 17, 2019.
Okay.
A letter from January 9, 2020. A letter from January 10, 2020, Mr. Scott Rosenberger.
So you guys didn't want to just text or email each other and just call it a day?
Additional letter from January 14, 2020 on behalf of Brewers Hill Community Association.
Alrighty.
Trying to put these in order so I can follow.
Right.
And Mr. Chairman, just a note, we do have these in the record, so.
Oh, you do? Okay, well, all right.
It's for the benefit.
There are some additional, so that's what.
Make sure we get them all.
So also a letter from January 14, 2020 on behalf of Brewers Hill Neighbors, Inc.
Wow.
Oh, they have the other one. Okay. There's also a handout of a PowerPoint presentation.
That.
And in addition, here are copies of several boards and exhibits that we have for the presentation.
Okay.
Okay. I would like to start off by just giving sort of a brief introduction of the interested parties and also the property at issue.
Yes, sir.
Gunther Bottle LLC is an entity that's associated with the Brewers Hill PUD, which you can see is
I can't even see where you're pointing at.
Here we go.
Brewers Hill PUD in this area here, along here.
What does PUD mean?
Planned unit development. The parcel of land that's at issue here for purposes of today is right here, this parcel. This is a parcel of land that was purchased by the permit holder from Exxon recently last year. And this triangular, or this sort of triangular portion right here is what we're talking about for purposes of today.
Who bought the Exxon property?
Permit holder.
Okay.
So the whole triangle is owned.
By.
Got it.
Okay.
Do you think it'd be easier to look at this?
We can also,
I don't think this is easier.
Okay.
so again, to reorient you, this is the Brewers Hill PUD up here. This is the Exxon parcel on this side here, and this is the parcel of land that is the subject of this hearing today. The city-owned land is this strip along here.
Okay.
This part here is a parking lot that was previously licensed to Gunther Bottle LLC, is now licensed to an entity called BCP Investors LLC.
Who's that?
BCP Investors is another, it's another entity that's associated with Mr. Saperstein. This portion here is also owned by the city. So the entire site, the Exxon parcel consists of 11.83 acres. It was purchased by Refinery Canton LLC. As I mentioned, in addition to Gunther Bottle LLC, you also have letters from other neighbors. You have a letter from Mr. Scott Rosenberger. He's the owner of the Broom Factory, which is a neighboring property. You also have letters from the Brewers Hill Community Association and Brewers Hill Neighbors, Inc. In our letters submitted on October 16 and December 13, we described 3 different configurations of land that were the subject potentially the subject of the permit. We noted them as configurations 1, 2, and 3. For purposes of this hearing today, this is configuration 3, based on the letters from Rosenberg Martin.
What is configuration 3?
The yellow.
Yellow.
The yellow portion is configuration 3. And for purposes of this hearing today, we are assuming that configuration 3 is the applicable configuration for purposes of the permit application.
Okay.
So you're not talking about 1 or 2 today, only 3?
Correct. And the reason why we set it up that way in our letter is because we couldn't tell from the materials that were available to us which configuration was considered. So we laid out 3 different options. For purposes of today, we're talking about configuration 3.
Is there any stipulation as to what configuration?
Could I maybe mention something?
State your name, if you would.
Again, it's Rick Deal. The permit application was submitted with the address 1200 South Haven, which represented the full 11 acres of the former Exxon site, and it was before any subdivisions had taken place. So the address that was submitted was the address for the entire 12-acre parcel. I believe subsequently that we've determined, I think both parties would agree, that the application is for what amounts to the subdivided parcel that's represented by the area in yellow.
Yeah, that's correct. We'll stipulate to that.
Okay.
That particular parcel does not have a separate address, though.
It does now.
What is that?
3800 Boston Street. Is that right?
3800 Boston.
3850?
38.
Whoop, bad question.
Hang on.
So what does this represent, this colored area?
I believe this is the site that the building permit was being pulled for.
3800 Boston Street.
Okay.
3800 to 3824.
We added the red X's because while this is a site that the building permit is for, it's comprised of two pieces. One is the private subdivided lot that Caroline just mentioned as addressed, while the red X's represent the portion that is intended to be consolidated with that lot. It is currently owned by the mayor and city council.
But it's not a separate lot, correct? It's a right-of-way.
It's a right-of-way, correct. And it's a right-of-way that actually goes from Conklin Street all the way to Haven Street, and there's a proposed subdivision that has not gone through the process yet, where it would be subdivided, correct me if I'm wrong, Caroline, please, into lot number 1, and then 2, 3, and then there's a little piece that's part of the road that would be lot number 4.
Subdivided from the rest of the property?
Yes, ultimately. That's not at all the subject of this particular appeal. We'll get into that in our positive appeals a little bit.
Just so that I'm clear, I got the configuration number 3, the yellow. The red, so compared to that chart back there, is that green section that says Boston Street parking and all the city.
Correct.
All right, I'm good.
Yes.
I'm good because she's good.
Everybody's
Boston. Everybody's
Wait, what
good.
did you say, Michelle? Boston Street
So if
parking
you
lot?
see that,
Yeah, and
Boston,
city.
it's all of that. That entire strip is that red X area on this.
Gotcha.
But refinery owns the land at this point. The city just has the right-of-way still.
The city owns the right-of-way parcel.
Yeah.
They had originally taken it as part of a potential widening of Boston Street when the red line was proposed to come in. Now that that's not happening, they realize they don't need that much space for the right-of-way. They've agreed to subdivide and convey it to us.
Okay.
And the city owns the land, refinery does not own the land,
Correct.
Okay.
does not own the land.
So in our letters, we laid out multiple different reasons why we should prevail on this negative appeal. There are 5 reasons. We'll go through each of them in detail today. Improper setbacks, improper rear setbacks, improper front setbacks, insufficient parking, failure to apply PUD provisions, and a conditional use permit is required. If any one of those is accepted by the board, then we will prevail on this negative appeal. Mr. Deal is going to walk through each of the factual basis for each of those 5 arguments at this point.
Okay, let me just be sure, procedurally, the permit obviously has not been revoked. It's pending. Tell us what that is.
Okay, so the permit is stayed at this point.
Stayed.
So it has not been revoked. We have a, so I'll put the copies in the record.
We can't revoke it, but we can.
We have copies of a November 2019 letter from the Department of Housing and Community Development staying this permit. Right, it's staying the partial
What
permit.
are you asking the board to do? I just want to be clear that I understand. I mean, I understand this is a negative appeal. I'm clear mostly about the varying parcels of land. I need to be clear what you're asking.
We're asking for the board to invalidate the permit, the partial permit that was issued,
Okay.
based on the 5 reasons that we'll go through in detail.
You want me to jump in?
Yeah.
Okay. I'm going to utilize the PowerPoint, the larger handout that we did. I'm going to try to go through it as quickly as possible. I'm not a lawyer, I'm a developer, so I'm not as versed. So I'll get through it quickly. I'm going to read some of it. I'm going to skip over some, but I want to try to get through it as quickly as possible for everybody. There's 5 major reasons why we believe that the permit that was originally issued is now stayed should be denied. And those 5 reasons are reasons that are zoning violations or do not meet zoning code. So I'll jump into them. I'll go over them real quickly, let you know which 5 I'm going to cover, then go in a little more detail, and then hopefully wrap it up. So the rear setback, we believe that this is a C2 zoned parcel. The rear setback for the property should be 20 feet. It's in the code. It's noted here on page 7, the table and the section. The rear property line is the key to being defined where that rear setback should be from, so we'll go into detail of what the rear property line is. Also, in C2 zoning, the maximum allowed front setback from their property line is 5 feet. And the proposed project building is more than 5 feet from the front. They have not asked for a variance for that, so I believe they should not be allowed to get a permit for it.
Mr. Deal?
Yes.
And I'm going to ask this for each one of these. Do the positive appeals filed for these properties cure any of those issues?
No. While all the parties are the same, this one is a much more in-depth because this is a building permit. We have some similar arguments about why we believe that their variances shouldn't be issued for the positive appeals, but they're not really related, and they're not as detailed as this, because this has a full building permit involved with it.
But if there's a request to put something in a setback, and then in this case, a partial permit is issued, and then on the heels of that, a positive appeal for the same setback.
I'm sorry.
No, go ahead.
The positive appeals are for different buildings on different subdivided lots within that large Exxon parcel.
Okay.
Completely different area. This is the positive appeal. We're talking about this property right now.
Got it.
Okay.
Thank you.
Yeah, and the reason we're really here with this is because, as we talked about, well, I'll jump into it in a second. Let me finish.
What
Give
is your
5.
interest in this?
That's where I was going to go.
That's where I want to
That's what I was going to do on the next 2 slides from now.
That's fine.
The parking is, they don't meet the number of parking spaces required for the building that they've proposed. They don't meet it on-site, they don't meet it off-site, and they don't meet it for the uses they've proposed. The part of the property that they are proposing to build this building, the building's called the Wheelhouse. It's
That they're proposing.
that they're proposing is on this portion of the land, as we've already determined that this site is configuration 3. This portion of the land was part of and is part of the Brewers Hill PUD. So it's within the PUD, and per the zoning code, they need to get a minor change for use, or they need to remove it from the Brewers Hill PUD with a major change. And lastly, I believe that the proposed building, as they've shown, as they've marketed it, as they've talked about it, and they've developed, same owners developed a wheelhouse in Federal Hill. I believe that building qualifies as a rooming house and not a multifamily. And as a rooming house in C2 zoning would require conditional use, which has not been applied for.
Why do you think it's a rooming?
So I had a whole bunch more. I can definitely answer that when I get to it. Do you want me to go out of order? Can we go through the slide quickly?
You can go on.
Okay, I'm sorry.
When are we going to discuss your
Right now.
interest in-
Why are we an interested party? We're an interested party because we are the developers and owners of the Brewers Hill PUD, all of these properties, and we believe that the proposed building negatively impacts us. We have a 1,700-foot property line that we're sharing with the applicant, including for this particular parcel. What we believe is their rear property line is our front property line. We have an active building with retail and office and users that we've developed over the last 20 years. So we are the closest property to that, to this development, and we believe it'll negatively impact our ability.
Did you ever try to purchase that property?
Did we try to purchase the property? Over the years, we've tried to purchase the property many times. Yes.
And?
For a very long time, Exxon said that it wasn't able to sell the property. They said that it was hadn't been remediated enough. You know, I believe Mr. Saperstein was fortunate to be able to purchase the whole large parcel, but we weren't able to. What we did have is a license agreement from the city as an inducement to start this PUD back in 2000 or 2003, to take this, which was unimproved. We built this parking lot. They licensed it to us for additional parking as an incentive.
When's the license expire?
That's actually being debated, and it is actually in court, whether or not our license is still valid or if the new license to BCP investors is now in place.
So I'm going to go over just the setback ramp of the cars
Mhm.
and point out.
Yeah.
This is one of the major.
So what's really impacting us and why we're interested, I mentioned the 5 reasons, but the setback and the parking are the 2 key things for us. As an operator right behind them, this is from the applicant, I guess we're the applicant here. This is from the developers UDAP presentation. I know there's probably been changes to it, but this is the rear of their building. It's the rear of the building as they talked about it at UDAP. This building is shown 4 to 6 feet away from the rear property line, our front property line. And these cars, they're shown on our property. So that's how close they would be putting a building to our property.
So
So the building rides the line, like it's on the line?
It's like 4 to 6 feet from the line, depending on how you measure it.
So if you were to walk out the front door of your property, are you saying that building would be 5 feet?
Their building is slightly offset from our building. This is the front of our building. Their building is slightly offset, but we
Here's
own.
that facade you're looking at.
Okay.
Is there a road, there's no road or?
It's a
walk-
there's a parking area. We assembled a number of individual lots in order to build this retail building, and with the Panera. And
Yeah,
Where's the building go on that lot?
this is our building.
Yeah.
Their building goes basically.
It's right
from-
here, which is right there.
Right,
That's their building.
their building goes basically from the K in parking and kind of hugs this line. I'm sure they have a picture.
What's the difference, what's the distance, I mean, from your existing building and the proposed building on the?
I don't know the exact distance, but
But I mean, but you were,
maybe
Wait,
what
before
you
you-
told
60
us
feet.
is
Before you-
it's 4 feet.
Before you pass it
from the property line.
That's what I'm asking, what is the difference to the building?
Oh, from here to there is 4 to 5 feet. From here to
No,
this
to the
building.
building, yeah,
Okay, I'm going to show what building. From this one is probably
Existing building.
70 feet,
okay.
roughly.
Now,
I
we
only
are,
asked that because it seemed to me you
I
were
get you.
trying to tell us that your building is 4 feet away from the proposed building.
so we're developers, and we've built out the Brewers Hill PUD. We have 30 acres of land, and we have entitlements through the PUD to build. Currently, the parcel that is the bottle building, the building you're saying, how far away is it from the line? That building is a 1-story, 60,000 square foot building. We own all of this parcel. We are entitled, if we want, whether it's Wells or his son, we are entitled to build out this lot. I mean, there's a possibility that we would improve this with a 300,000 square foot building, in which case we would want to maintain our development rights and be able to build to our property line.
Yeah. So where is,
We're confused
can you tell
about,
me where Rev is? Rev and Polished and?
Yes, they're within our PUD,
just be able to
within the Porter apartment buildings. See the dead center of the building, the thing, right there.
Yep.
Okay.
where is the building going? Here?
Yes.
No, it's going further to the right. It really doesn't block
Here?
the building at all.
Here?
Right.
For all parties in interest, we need to take a pause real quick.
Right.
Number one, our court reporter needs to pay his parking meter, so we will take a 5-minute break.
Okay.
When we return, it is very important that people speak one at a time, that you wait your turn, that you wait for a question, that you answer that question, and then when allowed by the chairman, that you proceed with your testimony. So, Mr. Chairman, at your direction, we can take a 5-minute break.
Yes, let's do that.
Good idea, Derek.
I feel like it's hot bench. We're like, what?
Okay, great. We can go back on the record. I'd like to pose a question.
Yes.
To you or counsel, Mr. Van Halligan. We're here on a partial permit, right? I recognize that the permit is pending. Could you just summarize the legal authority to challenge the partial permit? given that the city has an opportunity at some point to pull it all back.
Yes, and I would also ask that if we could reserve some time for rebuttal, potentially after council's arguments on that point. We'll say I can provide you with a letter that we sent on November 1, 2019 to the Department of Housing and Community Development.
This is new, what we don't have, right?
Correct. And cited within this letter is the Armstrong case, Armstrong versus Board of Municipal and Zoning Appeals, 169 Maryland App 736. That case says, in the absence of a certificate of imminent peril, a stay of construction under a permit is mandatory during the pendency of a negative appeal. It also says the right of aggrieved persons to take a negative appeal would often be rendered meaningless if construction under an illegally issued permit were allowed to continue. Based on that, the Department of Housing and Community Development issued a stay. The reason why we are proceeding here today is because the partial permit that was issued was for foundation and footers. Our argument is based, among other things, on parking and setback. The foundation and the footers for the building will determine the location and the size of the building. Based on that, the arguments are ripe now to determine the issues surrounding the parking that's required, the setbacks. Certainly the setbacks won't change once the foundation and the footers are placed.
I suppose that's the question, right? So a partial permit, and I'll for the record, I'll read the permit into the record. It's comp permit 2019-03318. Partial permit subject to all conditions of agreement on file for footers, foundations, underground utilities, slab on grade, podium for residential multifamily dwelling, pending action on application for plan number 2019-1479, the issuance of the general permit, and the understanding that the engineer architect will comply with Baltimore City building and fire-related codes. So isn't the developer proceeding at their own risk? So if there's a partial permit to put a footer in that corner of the room, and that partial permit is issued, and they put that footer, and then when they come for their general permit, this board or any other board says, no, you're denied. We don't give you that variance. They just wasted $20,000 on that concrete. Is that accurate or not accurate?
That's true. However, the reason why we're bringing this now is because we could see a situation where several months down the line, if the foundation, the footers are in place, the partial permit is issued, and we file a negative appeal at that point, the argument could very well be made, well, why didn't you file these same arguments previously? You knew when the foundation, the footers were going to be poured, where the building was going to be. You had the setback arguments available at that time. The parking arguments were ripe at that time. So we're trying to pursue this in the most efficient way possible. The developer does proceed at their own risk, but the issues are ripe at this point based on the nature of the work that's described under the partial permit. It is at their own risk, but the issues are already there, and so it's our position that they can be decided at this point. And this is also a partial permit. This is not a separate permit. This is the full permit was applied for, the same permit number. The partial permit was just pulled for that, pulled from that. In the meantime, while it was still being considered. So the reason why we're pursuing this here today is to sort of try and be as efficient as possible, try and resolve the issues, and avoid a situation in the future where an argument is made that there was some sort of waiver of the arguments, or they could have been considered at this time and they weren't, and therefore, they say that the developer can continue at that point.
I can understand the preservation argument. I would simply add that when there's a general building permit filed, the Department of Housing and Community Development views it differently than a partial permit. And that I can't speak to their processes, but a general building permit would go through the normal process. So it would be shuttled through to zoning. It would go through all those steps in order to catch any instances where there would be a corner of a building in a setback or a height violation or whatever it might be. I'm just interested to hear, and I think you've answered that question, and I will pose the same to the permit holders when it's their time to testify about this board's authority to invalidate a partial permit that is not the full building permit that would ordinarily come to us eventually if variances were required. So I'll just leave it at that, and unless the chairman has additional questions.
And Mr. Chairperson, I'd also add, I'd like to introduce this in the record. This is an additional handout on that specific issue of the partial versus full permit. And I will say that the reason why the Department of Housing and Community Development did issue the stay on this permit, understanding that it is different than the full permit, the reason why they issued that stay is for the very reason we've stated, that the issues surrounding the placement of the foundation and footers are critical to the issues surrounding setbacks and parking and the other issues that we're raising in this negative appeal. So that's the very reason why the stay was issued at this point, even though it is a partial permit. And so that's the reason why we're here and proceeding today on these arguments.
Okay. Let me also, just to piggyback on that, would you consider your client to be aggrieved if, in furtherance of the partial permit, I guess had the stay not been issued, they went ahead and poured the footers and laid the concrete, but then the permit got pulled back and they had to break it all up and take it all away? Would you, as a adjoining property owner, be aggrieved as a consequence of that whole process in any way?
I can let my client speak to that further. I will just state that the one thing that we would say is that once that is poured and once that is in place, even though the developer is proceeding at their own risk, we wouldn't necessarily have any recourse to stop the further building of the structure at that point. So the reason why we're raising it now is because we're trying to prevent the construction of that building, before we get to that point. So,
Rick Deal, one more point I'd like to bring up. The permit is for site utilities and the other associated pieces with the foundations. The first step when the contractor is released is they're going to come in for the full site, the area. This is the building. I thought it might be helpful. We found this drawing. So this is the proposed building. This is our building. This is our property line right here. And they would come in and they would start grading. As I briefly mentioned before, part of their site is this public right-of-way, which we're contesting in court, and we believe that we still have a right to. This right-of-way was improved by a parking lot where we put substantial money, close to $500,000, into the remediation and construction of the lot. That lot would be torn up and taken down immediately as they started putting in their utilities. At least I believe they would, from my experience. And I think once the process starts, it's very hard to stop somebody from building, and it would be way more than $20,000 of concrete going into the ground. There'd be substantial construction going on, putting in the foundations.
What's the city's position related to the parking lot that you guys put in?
So the Board of Estimates gave a 5-year license agreement, 1 year of which is passed, to BCP investors for parking for the Canton Crossing development across the street. That license has 4 years left on it. We have appealed that Board of Estimates decision, and it has not made it through the courts yet. So the current position is that it's licensed for about 4 more years. There was a 5-year license for parking for Canton Crossing across the street. That's, to my knowledge, that's the
only stated purpose on that license agreement.
I would mention that this building, which is now under construction with a full building permit, which we did not oppose in any way, is a grocer and retail, and it was issued a partial permit to start foundations. Its full building permit was issued on September 30th. By October 7th, the picture on the handout we just gave. Page 8.
Did that property require variances or further review? I mean, if it didn't, this is a situation where, based on your argument and your handout, the developer is going to have to come to zoning to be, so I guess we need to hear from them at this point. I'm not trying to cut you off, but I think it's critical to hear from them what their intent is at this stage, because we're talking about a very early stage in this process. So I actually am gonna cut you off. I'd like to
Okay.
hear from them. Thanks.
I want to clarify one thing just from a factual perspective, and maybe, either can you grab our board, or may I borrow your board? We have the same board over there. The distance from, between this building and this building is about 70 feet. The parking is, 20, 20, 20, it's 60 feet of asphalt, and that's about, give or take, 70 feet between the two buildings. The proposed wheelhouse building is not directly in front of the bottle building. It is offset. It doesn't sit directly right in front of it. So I just want to clear that up.
So is the wheelhouse building, because there's been testimony that the wheelhouse building is going to be 4 feet from their property line. What is on their property line right now?
It's actually going to come right up to the property line.
And what is on their, what are they using, what would that be, what is the building going to abut directly?
The parking, that parking lane on the adjacent property.
First we've heard it's gonna be right on the line.
It's on, I mean, it's on the plans.
Right.
The plans that are in front of the board today on the partial permit. And actually, maybe it would be helpful to get into a little bit of the substance of the setback issue, because I think that the filing of the appeal of the partial permit was a little bit premature. And this is set forth in the letter that we sent to the board, but the permit isn't for a structure that houses a use. It's not a quote-unquote building. It's for foundations, it's for grading, it's for footers, it's for utility work, but it isn't for a building that houses a use. And a building is what triggers the setback requirements under the zoning code. If it were to trigger the setback requirements, assuming, which we don't concede, but assuming for the sake of argument that the setbacks are required, we actually did our homework on this when we first started this application process.
Can I just interrupt? And I'm
Yes.
sorry, because this is a lot. Is it your position then that the setback question hasn't been triggered yet?
Yes.
That it's not yet ripe?
Yes, but even if it is ripe, we don't need a setback variance, and we won't need a setback variance.
No, I understand. I mean,
But
I
yes,
think that
that
might be
is-
for a separate, another day potentially, but what you're talking about is that the setbacks aren't ripe, and then parking, I guess.
Parking use, none of this is in front of the board today. We haven't applied for a particular use, and so it's impossible to calculate exactly how much parking would be required. It's entirely speculative at this point. Based on, obviously it's going to be a multifamily building, but we haven't applied for anything particular. And so when we apply for a building permit, we'll have to demonstrate to the zoning administrator's office that we meet the parking requirements, that we meet the setback requirements, that the use is allowed. All of these things will be addressed in the issuance of the actual building permit for the site. So I think that this negative appeal is premature. I understand that the appellant wanted to preserve their rights and make sure that they didn't waive anything, but I think that in this case, the only thing that's in front of the board is what was approved by the city, which is, grading foundations, footers, utility work.
Let me ask you, I'm sorry, go ahead.
Let me ask you, you expect the city parcels to be consolidated?
Ultimately, yes.
Ultimately?
Yes.
What is your understanding of the city lease for the parking lot?
The license area in the front, as Mr. Deal indicated, it was awarded to BCP investors by the Board of Estimates. The city's position, with which we agree, is that the license agreement that the adjacent property owner had terminated. The city, in turn, licensed it to someone else, BCP investors, for the use of the property across the street for excess parking.
What is your response to the legal authority, the Armstrong case, with regard to the ripeness of the issue of a negative appeal when any construction might be undertaken?
When the ultimate building permit is issued, there is a 10-day appeal period from the date of the issuance of that permit, during which an applicant can file an appeal of that permit. This is not their last opportunity to appeal a permit. I think the only thing that an applicant can appeal is the thing that was approved by the city. And in this case, it's stated pretty clearly on the face of the permit.
The Armstrong case dealt with full variances. I think there was a use in there.
There was a use issue in there as well, and it's been a little while since I've read that case, but I don't think that case, my recollection of it, precludes or requires that this permit be revoked or suspended. I think the appropriate time to file an appeal of the building permit is when the building permit is actually issued. And at that time, obviously that permit will include the parking issues and the use issues and the setback issues and all the other associated things that go with the ultimate development of the property.
Okay, so what would be the consequence then if having the partial permit issued and it goes forward and action is then undertaken pursuant to the partial permit, including the placement of utility lines and things like that? Is it your contention that if the city then says, okay, we're not going to issue you a building permit, we're going to pull the whole thing back, you tear that all up, and then what?
You mean if the partial permit is upheld?
Correct.
And then the ultimate building permit is rejected?
Yes.
It would be, I guess the answer would depend on what grounds it was rejected. Was there a variance sought that was, denied? Then, I think that the city has the authority to deny a variance. They don't have to grant a variance. I don't think the city can arbitrarily decide not to grant a permit. I think as long as the building, and in fact, there's case law that it's a ministerial action if the application complies with all of the regulations governing the project, then the city doesn't have the discretion to decide not to issue the permit. They have to issue the permit. But if it doesn't comply with setbacks or zoning or parking or use or something like that, then obviously there would be grounds to deny it.
But does that mean all the work that you did under the partial permit then is for naught and you have to rip it out?
Yeah, and then rip it out, and so.
The answer is yes. If the ultimate building doesn't comply with the zoning regulations, Maryland actually has rejected the doctrine of zoning estoppel, in which a municipal authority would be stopped from granting a secondary or subsequent permit based on the applicant's reliance on previous approvals that have been granted.
Okay. And so.
So what you're saying is this isn't ripe, and if ultimately you don't get the building permit, it's on the developer to deal with those issues, and they're out of pocket and whatever else, and that's on them.
That's absolutely right. If we don't get the building permit because we don't comply with some type of other regulation, then that's on us. But we firmly believe that the building complies with all the applicable zoning regulations, and so we're comfortable proceeding.
Got it.
And so if the argument, correct me if I'm wrong, if you're challenging where this is going to be built,
Yes.
but yet the foundation is laid for where it intends to be built, even if they, down the road, say, oh, sorry, you can't build this now. If that encroaches on, it's not going to be on your property, but it's going to be within the.
Be right up to the property.
Right up to the property. Okay.
It's an interior side setback, which has a 0 setback under the zoning code. There is no setback required on that side.
We disagree with that.
We disagree.
strongly.
Okay.
And that's
All right. I was going to say, well, if that's the answer, then.
But I would just interject that those plans are not before the board today.
Right.
And so we would have no way of calculating that or knowing that, because under the permit that was issued, that is currently suspended or stayed, that never came here. It never went through the full zoning process. It never came to the board for review.
So let's assume, and I understand you totally disagree with everything she said, but let's assume that what she's saying is true, and that if ultimately the building permit is issued or not issued and there are problems and they don't get the variance they're requesting, et cetera, and they have to rip out everything, how have you been injured with them proceeding under the partial permit?
Well, first I'd like to say that I think that they've submitted for a full building permit. You can't pull a partial unless the full building permit has been submitted.
But the full building permit isn't why we're here. We're here today on a partial permit.
Right, the city hasn't made a ruling on that yet.
So we can
Right,
only
but-
we can only proceed today on this partial permit. And I understand that you guys are ready to go and you're gonna be here as soon as this building permit issues, you're gonna fight it to the end. I definitely get that sense.
Yeah.
I'm just trying to understand.
For the reasons I mentioned
Because
before.
I can't, my understanding from speaking to people who are smarter than me is that I can't decide things that aren't before me today.
So I believe we would be harmed because, as I mentioned, they're going to turn this into a construction site, and we've yet to resolve the issue about who controls the lot number 1. I believe that as soon as they they do know where their setback is.
About the right-of-way area.
I'm sorry, this area. It's defined as lot 1 in the subdivision proposed. I believe that they have submitted a building permit. If they had submitted a permit for a foundation, that would be one thing. But they submitted a full-fledged building permit, which included their uses and their parking analysis.
I feel like you're not listening
And then
to
they
me.
pulled,
I
yes.
don't want to hear about the building permit. I want to hear about the partial permit today. Like that, because that's all we can talk about today. And if we were talking about the building permit today, I think we'd probably need to set in this for a special day, because I think we're going to be here all day. So if we limit it to just the issue of the partial permit, that's what I'm interested in, which is why, I'm sorry, I interrupted you, and I wanted to hear from them so that I understood, so that I was clear that they understood what would happen if they then don't get what they're asking for, what the ramifications are for them.
Okay,
Which seems severe.
and following that, the reason for my question as to, is it just for not, sorry, we laid all this concrete and all this other stuff, we gotta undo it. I initially was under the impression that there was a concern that they would be encroaching onto your property as opposed to some other, right up against it. So if it's not on your property and they've gotta tear it up, what is the nature of of you being aggrieved under those circumstances? Is it a loss of business because there's a construction site going on over there? So, I mean, in some cases, in some respects, I can see, okay, there's a nuisance going on, it's impacting my operations. Is that the case or not? And if not, what else is there to,
So, I mean, we have in this lot, which is still unresolved, and at the risk of repeating myself, I'm sorry. I mean, we invested $500,000 in this lot.
Sure.
First thing that's going to happen under a partial permit is that gets ripped up.
okay?
The courts have not yet determined who is sort of the rightful user of that lot.
And in that other,
But that's not on us. You would have to go to
You
the
asked the
circuit
question
court
what the
anyway.
damages are,
No,
and,
but
right.
Are you, is there a restraining order pending or
Right,
some
it's
sort of
a-
injunctive relief? Because we can't give you that today.
Right.
We can only talk to you about this partial permit.
The other argument is that the footers and the walls are really inseparable. I mean, that's a little bit of a sleight of hand to say that, oh, we're only doing footers and there's no building there. Building walls are always right on top of the footers. I mean, come on. I mean, so we know exactly where the building wall is going to go. The height and the other thing don't matter.
I totally understand what you're saying, but what they're saying is that, and what it seems that everybody understands here, is that they're gonna have to get a separate permit for the building, and that we're just talking about footers, and if they don't get what they're asking for, they understand they're gonna have to rip it all out. So I understand you're concerned that eventually it means that they're going to be able to proceed with the footprint of the footers, but that would be illegal without approval. So, and you would obviously have lots of recourse if that occurred.
Right, and our argument is that the same reason why the stay applied to the partial permit is the same logic for why the partial permit should be invalidated.
What's the status of the, I'm assuming circuit court case dealing with the right-of-way? Is there a circuit court case?
There's a circuit court case, it's still pending.
I'm not involved in that case.
Okay.
so injunctive relief is available there.
Has anyone sought injunctive relief? Because that would be what I would think, as a litigator, that would be my move.
We have not at this point.
Okay, why?
We were proceeding with other options at this
Okay.
point.
Because this is one form of injunctive relief, if you
There's a stay on the
invalidate
permit at this point.
There's a stay of the permit, and there's a stay of the permit pending what?
Pending review by this board.
Okay.
They can't
That's
revoke a
like
permit
us.
without a hearing, and this is.
Pending this negative appeal.
So as a matter of process, when someone files a negative appeal, that's why it's reviewed by our office first to see if there's anything there.
Yeah.
When the formal negative appeal is recorded and paid for and given an appeal number, that is an automatic stay that's issued, not like a bankruptcy stay, but it's a suspension that is issued by the Department of Housing and Community Development. So that's just simply part of the process for every negative appeal that gets to the point at which it is docketed and then correct.
And I would just say, our position is that the setbacks are so intertwined with the placement of the foundation and footers. That's the reason why we're making those arguments here today.
I don't think I have any more questions about the negative appeal. Does anyone else?
Could I have a question? I'm sorry. By just handing out the handouts, is it entered into the record? Because I know you don't want to listen to this whole thing, but is that part of the record?
That is
Right.
correct.
If you want to tell us more, I just think I understand, I have a good understanding of what the issues are at this point.
I'm fine if as long as this is part of the record.
So long as there's no objection on some evidentiary level, everything that's been submitted is formally part of the record.
Thank you.
Thank you.
Trying to think of what else I want to hear from these guys. I think I want to hear her issues on why the negative appeal, all the reasons why the negative appeal is not right, unless you already said it. I'm going to just ask Ms. Hecker, you began to state your reasons for why this negative appeal is not right or appropriate. Did you conclude those arguments?
I think so. I mean, the issue is essentially that it isn't a building permit that covers, you know, all of the various setback issues and the use and the parking. And I mean, I, without having heard from them, it's a little bit hard to respond to their specific issues on those. I mean, I can get into the substance of it if you'd like. We haven't heard from them on it.
And we'll defer to you. And
I mean, our position is related to the fact that the building is going to go where the footers go, and that there's the 5 zoning reasons that we mentioned before, and that we believe that the partial permit is being pulled for this whole parcel, and that by zoning, even that the setbacks are the most important thing because it comes up to our property line. And while it may be 70 feet from the existing building, and while there may be parking as a use here, this is a PUD, and our PUD has approved uses. We have density left in our PUD, and we could, in the future, develop for a higher and better use for this lot, which this would be our front property line. And as Ms. Hecker mentioned, their building would be on our property line. So when we go to develop our property, when we go to improve our property, we would now be expected to build up to our property line. Underlying zoning, the historic nature of the properties are all up to the property line, but we would be prevented from doing that. We couldn't build a building up to our property line as their building, as that large wall of their building would then be impacting our ability. So we would have to change our site development. We would have to make our building smaller. We'd have to step it back. So if this building was allowed to continue with this property line, you know, right on our property line, I can build back here, but I can't build a garage like we have here and build up. I can't build a garage like we have here and build up. I can't build a garage here and here like we have. I'd have to step it back because I can't be right up on the property line. So our argument was...
And again, obviously that theorizes the walls.
Yes, everything I'm going to say theorizes the wall. So, I mean, I recognize that, and I'm going to go quick. I'm not going to go through every detail. We believe that the use is they don't have the parking. They don't have the parking because by their own admission, as they said, they haven't calculated, but they provided in their letter a table, a calculation for their parking. And their calculation is only on the lot that they own. And that calculation does not meet the zoning by their own admission. Even with the shared zoning calculation, they said, hey, we need 71, and it ends up being 56 by their count. That's being very generous as some of the spaces are split between the city right-of-way and theirs. Either way, it didn't meet it. The parking is further exasperated by the fact that we believe we believe that the building is a rooming house. I won't go into the whole details of it. It's in our presentation, but that changes the use and it changes the parking requirement. And what happens in the real world when they underpark a development is that people are going to find a place to park, and they're going to park on our parking lot, and we're going to bear the burden of that. So we have parking, we have the setback, the rooming house if you would, obviously the building's not there, so whether you're hearing that today or not, but the rooming house would require a conditional use, and that's a variance that has not been applied for. The building, and this could apply to the partial, I think. The building lot, as everybody agreed to at the beginning of this hearing, is that it includes the city right-of-way. The city right-of-way lot, we believe, is, and it is in the PUD. It's in the Brewers Hill PUD. It was put in the Brewers Hill PUD as part of the ordinance, as noted in the PUD. And a lot remains in a PUD until it is removed by a major amendment. There's no way to get a lot out of a PUD unless it's a major amendment or a major change, I think is the new code transform, they call it major change. And even if it stays in the PUD, if you want to change the use, if you want to change it to a plaza from parking, then that requires a minor change, and that requires a variance. So the fact that this partial permit is for a lot of which the applicant does not own, has not licensed, does not have a 20-year agreement to put parking on as required by the code. Since it includes this lot, which is part of the PUD, they should go through the PUD process, which is either remove it by major
And
amendment.
that's covered by the partial permit, that work. So they would need to do the partial permit work, they would need to amend the PUD.
Well, first, PUDs are changed all the time.
Yes.
Yes, but they need a variance.
And
Or they need to,
if you cut to the chase, what I'm hearing you guys say, what I'm hearing you say that you're basically are against the proposed building because it might damage some interests of yours in the future as you build.
That's one of the reasons, yes. And secondly,
How's that legitimate?
this should be a 20,
If
by
they get
by
approvals
code.
for that building, how is that a legitimate?
Their testimony is that the building would be on our property line, our front property line. And by our rights, we're allowed to build up to our front property line, but no longer if this building is allowed to be put on the property line when the code requires it to be 20 feet away. We're asking them to move the building 20 feet. I'm not saying this building can't go here. I'm saying it can't go right here. It can go 20 feet down. They should shift it 20 feet, giving us the relief as a neighboring property from that building. So when we go to develop, if we put our building 5 feet from our front property line, as the underlying zoning requires, there's a 25-foot separation. The code works perfectly. 20 feet for them, 5 for us, 25-foot setback.
we're just asking if the zoning code be enforced. That's it. And if it's not enforced, we're aggrieved.
Ms. Haggard, just two very brief follow-up questions. Can you address the PUD issues? Number one, is this property within a PUD, and is there does the partial permit in any way violate any term of the PUD that would need to be amended? Number one. Number two, the partial permit does involve work on a city-owned piece of property. So what is the legal authority that you or your client have to go on to that property?
And I'll tag team, I understand that you're not involved in the litigation regarding that, but is that gonna move quickly? Like, I mean, presumably, you're not in a situation where you can.
All right, let me address a couple of different things. The PUD, the property, I don't have a copy of the PUD. I don't know if it was included in the documents that were submitted. As I recall, the license area is part of the PUD. I also believe, though, that the PUD provides that properties that are designated as part of the PUD will only be considered as part of the PUD when they're acquired by Natty Boh LLC, which was the PUD developer. This parcel has never been acquired by Natty Boh LLC and therefore isn't governed by the PUD. That's the position that the Planning Commission took when they reviewed the development plan for the project. They are the body that would approve a minor change to the PUD.
Your position that the right-of-way portion is not a part of any PUD, it's not, none of that?
It's not governed by the Brewers Hill PUD. And to the extent it is, if it were, it would be for the Planning Commission to approve a minor amendment, and we would have to apply to the Planning Commission for that approval.
Exactly.
Yes.
But that, again, is not before the board here today.
But that's a criteria for a partial permit.
Can we just hear from her? Is this a debate or what?
Sorry.
Go ahead, Ms. Hecker.
What was your second question?
If the partial permit is doing work on land that is currently not owned by the fee simple lot holder to the immediate north, because that right of way is owned by the city of Baltimore.
Correct.
So conceivably, you are trespassing on the city of Baltimore's land. So is there some authority that your client has in which to do that.
We have not started any work in the city right-of-way on that, in that city portion. We will have an agreement with the city for access to that property before any work begins. We certainly can't begin any work without the city approval to work in the right-of-way.
That's an important piece.
Right, and that would be obviously a prerequisite to any permit to.
Does the permit address portions of that land?
The permit isn't specific in terms of the area that it covers.
We could theoretically, if, depending how we, like, I mean, the permit should say that you can't.
Well, the permit is for actually only what was at the time 1200 South Haven Street.
Okay.
So I'm not sure that it technically does cover the right-of-way area. I wanted to amend my previous statement
What do you
because
think the permit covers?
the permit is specific in what it covers. It covers footers, foundations, underground utilities, slab on grade, podium.
I'm sorry, I meant where.
Oh, wait, I'm sorry. In the,
Sorry.
We're like, where on that?
Yeah,
it covers this area right here.
got it.
Okay.
This is the portion of what was 1200 South Haven Street at the time the permit was issued. Again, just to refresh your recollection, this is Haven Street. This whole property was one big property with the address 1200 South Haven Street. It was subsequently subdivided into, I think, 5 lots, one of which is this parcel right here. This is the parcel where the wheelhouse is going to be located and for which the permit was issued.
The partial.
The partial permit, thank you, yes.
I just wanted to ensure that there was a right of entry allowed for
There-
the city
there will
lot.
be. Yes.
If, you know, things are being dug and things are being placed pursuant
Prior
to
to
a
any
parcel
work being done, we absolutely will have an agreement with the city to do it.
And I'll just address that quickly. As of right now, the license agreement is with BCP Investors LLC. It was a 5-year license agreement that was issued approximately 1 year ago. And in that license agreement, it specifically says that the land is to be used for parking for the Canton Crossing development, and that's it. And it says there is no work to be done without prior city approval. It says that directly in the license agreement. So
Okay.
anything beyond that is a violation of that license agreement.
And we,
You're
and
the license, you're the license.
we're the licensee,
So it
yes.
doesn't- I mean, I mean, presumably you can come up with a new agreement as to the use of,
Correct.
okay.
I'll just address one point, that the portion of land we're talking about is owned by Refinery Canton LLC. The license agreement is with BCP Investors LLC. It's a different entity.
Different owners.
That is correct. It is a different entity. It does have different owners. Mr. Saperstein controls both entities.
I was gonna say, I thought.
Yeah, all right. I'm glad thank you for clarifying that.
Okay.
If you'd like to get into the substance of the issues, I'm happy to. There was some comment about a rooming house use. This is frankly the first I'm hearing of that, and
I think that's not right.
Okay,
I don't think we're ripe for rooming house arguments.
Okay.
at this point.
I can address the substance of the setback issues if there are other
I-
concerns. Oh, you had asked about the litigation, and I'm candidly, I'm not involved in the litigation at all, so I don't know what the status of that is.
Your contention is setback issue is not ripe either?
Yes, and even if it is, I don't think we need a setback variance, because this is an interior side lot line. The rear is the back portion of the parcel where it comes up into the triangle.
So you're saying by right you can go there?
Yes,
But we aren't even.
but I mean, I don't think that the board even needs to get there, but yes, that is what I'm
Raised
saying.
As an
Okay.
issue.
Mhm.
And given that the area we're talking about, which you just pointed out, is along the property line, which the negative appellant is talking about. Do you have a response to what you just said?
I would just say, with regard to the setback issue, I mean, if we'd just like to be heard on the setback issue. I mean, I understand the position, but, I mean, our position is the setbacks are intertwined with partial permit.
Let me ask a question about the setback. You're saying that there's a difference in a setback that you have to have for an interior wall versus a rear wall?
It appears that the Caroline, Ms. Hecker,
Uh-huh.
sorry, is of the belief that this is not the rear property line. We believe that it is the rear property line. Their site is a 4-sided site, the front of which, as defined in the code, is the property address and the only public street abutting their site. This is the front of their building. I believe the code defines the rear property line as the line that is directly opposite and furthest from the front. This is the front, this is the rear. The two sides would be the 60-foot side along South Conklin, or right-of-way by Conklin, and the newly created Eaton Street. So we have a four-sided property. The code is pretty clear. There's a front, the front's defined, the rear is opposite, the two sides are here and here. There's no need to find another way to calculate it. These four sides are there, and that's, the front and two sides. And I think everybody agrees that the rear property line would have a 20-foot setback. And the footer should go, not inside, it should be respect where the building's going to go. It's for their benefit. Why would you want to have to tear it up if you could decide right now where is the rear property line? Which is the rear, which is the side, which is the front?
So if I can respond on the setback issue, I had prepared a series of exhibits, some of which are repetitive of what you have already seen. But in this file, you'll see, one of the things that we did when we first started this, sorry, I'm not facing you, was we went to meet with the zoning administrator because we had this question about how do you measure the rear yard setback when you have a triangularly shaped parcel. And you'll see, in the file that you've got in front of you, you'll see there's a copy of the permit and there's a copy of the subdivision plan. And then you'll see that there's a letter that we received from the zoning administrator as a result of our conversation with him, and a copy of a plan that's behind it. And what he confirmed for us is that, if you look at the zoning code, how the yards are defined, the front yard is defined as where the property is addressed. When we applied for the permit, it had a Haven Street address, and the rear lot line is defined as the lot line that is most distant from and opposite the front lot line. And then in the zoning administrator's letter, he says the required rear yard is measured perpendicular to the rear lot line. The attached drawing shows compliance with the rear yard. And the drawing that's behind it is the drawing that was submitted with it. And as you'll see, at the time, the front was on Haven Street. The rear was back here. He determined that you draw a line perpendicular to the point of the triangle, and that is the distance that you measure to determine the rear line. So when we had the property subdivided and the property turned into a differently shaped triangle, the second thing that you'll see behind that is an updated version of the plan. The parcel in question is this parcel down in the corner here. If you use the exact same logic, you end up with the rear lot line being drawn perpendicular to the rear yard, which is the point of the triangle up here, and you'll see that it's 193 feet deep from that line.
93.13.
Correct, yes. And that is how the zoning administrator told us that we should be measuring the lot line and where the rear yard should be for this building. It wasn't something that we invented out of thin air. We went and sought the advice of the zoning administrator, and that was how it was determined.
But that variance is not before the board.
We have not requested a variance based on this letter.
All right.
And the configuration of the lot is not a triangle. The configuration is a four-sided parcel with two sides, a rear and a front. The code tells us what the front is, the code tells us what the back is, and the sides. I don't find anything, maybe Caroline, Ms. Hecker can point to where in the code this methodology that was utilized by the administrator is present. I don't see any reason to find a new methodology. I believe the administrator mistakenly was looking at this site without consideration of the proposed building and the finished lot.
Have you had any conversations with the administrator about this?
So I spoke to Charles Lee, who I believe is not the administrator, but works hand in glove. And I spoke to him at the Planning Commission time. And at that time, he only showed me the calculation he did when it was a 12-acre site. No building was present. The address was 1200 South Haven, which would make this the front property line, thousands of feet away. Yeah, so this was what he showed me a calculation based on. And, this being the only public street, maybe he thought there was going to be a building here. I don't know. But what we have now is an application for this site. And it's a four-sided site. It's been subdivided.
That site.
It's been subdivided and it's been proposed, and the building permit was submitted with full drawings showing this finished lot.
And
Not this.
the letter from the zoning administrator shows the configuration of the buildings. It's not a blank site. It shows where the buildings are proposed to be located. And it shows that this is a triangular lot. There's been some comment that it is a four-sided lot. It comes to a point on the corner before Conkling Street.
Which one, we decided, I'm sorry, you go ahead. At the beginning of the hearing, we decided which is the lot we're gonna consider.
Yeah.
Right, that's how we started this meeting. And we all decided that this was the one that we were agreeing on. Now they're changing it and saying, no, it's this.
What's-
We agreed in the beginning.
They're talking about that the permit work is only going to occur in the smaller triangle.
Right.
They're saying that they're not gonna do any work in the, section,
The red X,
the city portion. So I don't think there's any, no, I don't think anyone's trying to be contentious about that. Am I right?
Yes, that's correct.
I'll just say that when the full building permit was submitted, because they submitted for a full building permit, they submitted this lot.
But the full
But
building
the-
is not
I thought
before
that-
us.
But I thought, yeah, okay.
It's not before us. We're literally here on a partial.
Were you,
What is the partial, which partial is the partial for? And at the beginning, if we decided,
just the smaller
Just
triangle.
the small triangle, the yellow.
so not,
smaller triangle, not the
nothing that
red.
has the red hash marks in it.
Yeah, I thought when we were looking at this, that the red X indicated that that was removed and that we were talking about the yellow triangle.
I don't think they've ever thought it was removed. I think
Correct.
they were just indicating that to be a portion that's in dispute with the city.
Yeah.
Right.
So,
Right.
yeah. I mean, it's clear there are a lot of issues here. The question is what we can do today about this partial permit. So that, I understand from everyone's perspective that it seems interrelated, but we can't talk about what is coming next. We can only talk about what's happening now.
Where are you in your intended presentation? Have you?
All over the place. I mean, I believe we've hit on the points.
Okay.
Let me speak to your counsel,
Yeah.
Mr. Penhaligon.
I mean, I think we're satisfied with the record that's been submitted at this point.
Well, no, and you guys created a beautiful record, and your PowerPoint is beautiful, and
Yeah.
there's a lot of things for us
Despite
to
how we
consider.
feel about what's at issue, and, because that may yet to be decided, what's really in front of us. I want to be sure you've had an opportunity to make your record for this particular hearing. Ms. Hecker, similarly?
Yes, I don't think we have anything further to add.
Okay. Any questions from the board?
Nope.
Now, we have the issue where we haven't addressed the positive appeals.
I forgot about that. Yes. All right, let's do it.
So I've already called those cases, all right, and the addresses are,
Shall we switch sides, or do you want us to stay where we are?
it's fine to stay where you are.
Do you have a suggestion of what is the best way to proceed so that this doesn't get, first of all, super long? I have a 5:30 hard stop, and also.
And what time is it now? I'm sorry.
It's 4 o'clock. Do you think that's enough time?
I
Okay.
do, yeah. I think what I'd like to propose, with the board's permission, is that we proceed on the common facts that are together for all four cases.
I love that idea.
And then, I've prepared binders that have a series of exhibits that Mr. Williams is going to hand out for you. That you'll see as you get to the back of the binder, there is an outline of the facts that are common to all four cases, and then there's outlines for each of the individual cases that address the legal standards. What I'd like to do is proffer the testimony about what these four cases are about collectively. We're happy to answer any questions. As I said before, our site engineer, John Kraft from Kinley Horn, is here. The developer is here as well. We're happy to answer any questions that may arise, and I can go, I guess we'll see how long this takes, but as I get to the legal standards, I'm happy to go through all of them line by line, but they're also proffered and written out for your perusal in the binders as well.
Okay, thank you. Go ahead and proceed.
So,
This is not gonna be a debate format, I hope. You're gonna make a presentation?
I'm gonna make the presentation.
When you give your presentation, can you give us like a little opening about the history?
Absolutely.
So that I
Absolutely.
understand what's happening.
Please use
Very few abbreviations and as many actual words so that I can know what your abbreviations mean.
Yes, ma'am.
Thanks, I'm learning.
Right. Okay, so these are 4 applications for variances and 1 conditional use approval for the Collective at Canton, which is a $200 million mixed-use development currently underway in southeast Baltimore. The property as a whole is Zone C2. It's located in Canton. It is just under 12 acres in size in total. This is the most recent of many public approvals that this project will have gone through. We went to UDAP, the Urban Design and Architectural Advisory Panel in the Planning Department in June of this year to present a master plan, which is up here. This shows the overview of the whole site. I'll go into this in a little bit more detail as we go through. Also later in June, the city entered into a right of entry agreement with us for a portion of the Boston Street right-of-way. And I guess I should point out the exhibits as I'm going through this. The first item in the file that I've handed out for you are the meeting minutes and the full presentation to UDAP, the Urban Design and Architectural Advisory Panel. That was presented in June. It has a series of site studies and explains what the whole project is about generally. The second item that you'll see in the file is the right of entry agreement we have with the city for the portion of the Boston Street right-of-way. This is not the area that was shown in green on the plan that the appellant had in the earlier case. This is the remainder of the Boston Street right-of-way parcel. This is area that was, as I mentioned, originally planned for the widening of Boston Street in connection with the Red Line project. Once that project went away, the city realized they don't need this excess right-of-way. They have agreed to subdivide it and sell it to us. In August of last year, the city enacted an ordinance to remove this property from the boundaries of the Canton Industrial Urban Renewal Area, making a determination that industrial use for this site, it had been formerly, obviously, the Exxon refinery. I'll talk a little bit about that later, but was obviously not going to have an industrial use going forward, so they removed it from the urban renewal plan. In August, we also went through the Site Plan Review Committee, SPRC. A copy of the stamped site plan from SPRC is included as the 4th exhibit in the file. We were here in September, you may recall, for various height variances for certain buildings within the project, which relate to this, the 4 applications that you have in front of you today. In September, the board approved a 70-foot building, which is the retail apartment building, that is the Wheelhouse building, the 500-unit apartment building, which is the Gray Star apartment building, that is this multifamily building in the rear of the site. The office building also was approved to be 85 feet, that's here, and the hotel was also approved to be 85 feet, that one is down
Is that white
here.
thing a building?
That white thing, this?
No, up there.
Oh.
That's
Yes,
white, okay.
it's it's a 500-unit apartment building that Gray Star is developing. And a copy of the board's decision approving the height variances for those 4 buildings is included in your file as Exhibit 6.
Who is Gray Star?
Gray Star is an apartment developer. They're partnering with us on this site, on that portion of it. In October, the Planning Commission approved final subdivision and development plans, which subdivided the property that was known as 1200 South Haven Street into 5 lots. Copies of the subdivision plan and the development plan are included in the file as well. And then we've discussed this a handful of times. The subdivision plan that is in review right now for the Boston Street right-of-way is included in the file as Exhibit 7. That subdivides the city right-of-way portion into 4 lots. Lot number 1 that you'll see on that plan is the parcel that's subject to the license agreement that is still in dispute. Lots 2 and 3 are proposed to be, they're under the right of entry agreement with our client today, and they're proposed to be subdivided and conveyed to the adjacent properties due north. And Lot 4 is the part that's going to remain with the city for a proposed turn lane for Boston Street to improve access there. Let's see. So the next thing you'll see in the file is an aerial image showing the more historic view of the property. This is from Google Earth. The property is located along Boston Street between Conkling Street and Haven Street, across from the shops at Canton Crossing, and south of the Brewers Hill development, as we have discussed in extensive detail today. It is located along the Haven Street truck route. It's a heavy truck route designated by the city. A copy of the city's truck route map is included in the file as well. And then I've also included some Google Street View images of the conditions of the property prior to construction. You can see it's not a very attractive site to look at right now. It has a long history of oil industrial uses. It was operated by Standard Oil and Exxon for over a century. In total, was a 130-acre project. And there's some historical imagery in the file, as well as Exhibit 11, showing the tank farm that was located on this site. And as you can see, as late as 2005, there were tanks on the property. And we've also included an existing conditions plan in there, which was the condition of the site prior to our acquisition of it. The property is still undergoing environmental remediation. There are a number of monitoring wells that are still in place on the property. They're scheduled to be phased out over the next 15 to 20 years. Some of them come out a little more sooner than that, but the longer term ones stay in for a long time going forward. The location of the monitoring wells is shown on Exhibit 12. They're identified in red. You'll also see that there's a tunnel that runs under Boston Street that was a relic of the refinery that has to remain in place also for purposes of the environmental remediation. And so that the location of those wells is part of what is driving some of our variance relief that we're seeking today. And in 1997, MDE and Exxon entered into a consent agreement to provide for the remediation of the site. And since 2010, over 3 million gallons of oil have been recovered from the site. And there's a excerpt from a newsletter from MDE in there about the cleanup process that they've been undergoing. And this process was also part of what occurred at the shops at Canton Crossing across the street. They did an extensive cleanup there before that property could be redeveloped as a shopping center as well. And it was very successful, and we're doing the same thing on the north side of Boston Street now. So we acquired the property in February of last year, and I've included in the file an article from the BBJ about the project generally. Exxon sold it to us with our intent to construct this Collective at Canton project. And as I mentioned, we went to UDARP in June. We got approval from UDARP in June for the master plan for the site. The master plan and a few excerpts from that, which are the open space, are included in the file as well. But the master plan, as I mentioned, I discussed this a little bit before, but it includes 7 buildings. So there's the 85-foot tall, 500-unit apartment building that's being developed by Greystar. There's an 85-foot tall, 11,740 square foot office building, an 85-foot tall, 150-room hotel, a 30,000 square foot grocery store, which is going here, a building with 12,400 square feet of retail.
Could you step aside so?
Sorry.
No worries. Where's the grocery store?
Grocery store's right here.
Gotcha.
Retail, about 12,400 square feet of retail right here. It's also a retail pad site out here, which is about 2,400 square feet. It's proposed to be a drive-through bank. We're going to talk about that a little bit today. And then finally, the Wheelhouse building, which is over here, and which we have discussed extensively, which will be an apartment building. We are proposing a significant amount of green space for the project. You'll see in Exhibit 15 in the file, there's some of the details of the green spaces that are proposed. There's a significant green here, there's a gathering space here, and at the corner of Conkling Street, there's a plaza that is proposed. In addition, and very importantly, this project will be a critical connector of the Baltimore Greenways Trail, which is a route that runs 35 miles around the city, connecting important places in the city, anchor institutions. And you'll see the Greenways Trail map is Exhibit 16. The trail comes down here, it runs along the back of the site behind the apartment building, it comes down Eaton Street. This was something that we did at the city's request. Initially, we had proposed that it would come down of the rather wide sidewalk along Haven Street. We were setting the buildings back to be off the truck route a little bit. We thought that would be a good place for it, but at the city's request, we've moved it inside the site. We think that's actually a better configuration of it. It keeps it off of the major streets, and it'll come down and connect out here onto Boston Street. We are also working with BGE to relocate utilities located along Haven Street and at Boston Street and move them underground. The work on that is underway. The road at the Haven Street has been closed for about 40 days right now. We are expecting to reopen the street with late this week, early next week, which will be tremendous. It'll be, it's been, we understand that we've had the indulgence of the community while we do this work, but it's going to result in a much better situation for everyone. If you recall the street view photos that were a few exhibits back, there are a lot of power lines. It's really an unsightly entrance to the city, and by moving the utilities underground, we're going to end up with a much better looking gateway into Southeast Baltimore. So let's see. So we have, that's the next thing I've gotten here. So we have the oddly shaped parcels, the active wells, and we have the the greenway trail and the need for the public spaces, all that is driving our site design. The proposed uses are all permitted in the C2 district. We've done an extensive amount of outreach to the community associations. There's letters of support dating back from April. We most recently heard from Brant Fisher of the Brewers Hill Association yesterday. Mr. Baumgartner read a letter from him into the record earlier. The community has been very supportive of the project. They're very excited to see this happening, especially the grocery component. Excuse me. So to summarize the approvals that we are requesting, as I mentioned, there's 4 cases, and I can go into a little bit more detail about each of the individual cases, but each of the 4 sites requires a variance from the maximum front yard setback in the C2 district, which is 5 feet. The C2 district really doesn't contemplate development on a large scale such as this. It really has in mind that you're doing infill development within an existing city block, but when you're laying out new streets, new sidewalks, it doesn't contemplate the idea that you're creating new property lines and that these buildings need to be set back from those property lines so that you can have sidewalks and landscaping, and so that these other requirements in the code can all kind of work together. So for the Gray Star apartment building, and you'll see I'm up to Exhibit 18 in the file, there's an exhibit that shows the proposed setbacks for all of the buildings that we have applied for here. The Gray Star building is proposed to be set back, and that's the triangle here. It actually, I'm not 100% sure that we need a variance for this, because it turns out that this is only 3.3 feet at the corner here from the property line. So it is within the 5 feet, but at its largest point back, it's just over 30 feet on the plan, 31.8 feet deep from where the property line is. The hotel is also proposed to be set back. The property line for the right-of-way runs kind of across the middle here. Obviously, the hotel is going to be a much further future phase. It will ultimately be set back 21.1 feet from the property line. That's to allow a landscape strip, a sidewalk, and additional landscaping between the Boston Street frontage and the hotel building. I don't think anyone would want to see the hotel building within 5 feet of the Boston Street right-of-way, which would be what would be required under the city's zoning regulations. The office building, which is located here, there's a property line that comes across in front of the office building here. It's set back 22.4 feet from that property line. That's its front property line. And that's an existing property line now. That's not the city right-of-way line, which again comes through about here. The retail building here also requires a setback variance. It is shown as about 11 feet off the property line that comes across the middle of the site here currently in the current condition. In the future condition, it's about 117 feet from the Boston Street right-of-way, so once the lots are consolidated, it is a larger variance request there. With regard to that site as well, we're also requesting conditional use approval for the drive-through for the bank pad site that's proposed to be located there. The planning department is supporting that. That's I think the only appeal that they have entered a opinion in, but they have a positive staff report on that. And then for this parcel as well, we're also requesting a signage variance for the grocery store, which is Sprouts. And that, I'll talk a little bit more about that when I get into that case in more detail, but it's a larger sign than what would be permitted under the zoning regulations. As I mentioned, most of the variances relate to the maximum setback that's set for the C2 district. And, it really, like I said, it seems that the C2 zoning regulations really didn't contemplate the idea of a new development parcel being created with private streets and private sidewalks. It really only thinks about the idea of a building being built right up to the city right-of-way. But when you're developing a new project with you're developing a new street grid and building your own private streets, the property line will run down the middle of the street ultimately. And so each property owner will own to the center line of the street. And as a result, the building has to be set back more than 5 feet off of that center line in order to provide.
Question.
Yes.
Will all of these units and all these buildings have a Haven Street property address?
No, they all have Boston Street addresses, which is what's driving the need for the setback variance.
Including the one that's on Street A, which I assume is a new street? Does that say street A?
I'm sorry, where are you?
Between office and retail?
Oh, over here?
So the office building, that small retail, and the hotel would all have a street A address or still a Boston
They
Street?
all have a Boston Street address.
Okay, and what you were holding your pen to just above that, that's not a street, correct?
That's not a street.
All right.
It's just a driveway access.
Okay,
That's private.
It is all private. All the streets are private within the project.
gotcha. Including the piece of Eaton Street
Including the piece of Eaton Street
and Toon Street as well?
and Toon Street, yes.
Okay.
Yeah,
That's Boston.
they're all, sorry?
That's why it's Boston Street.
Yeah, that's why they all have Boston Street addresses, because that's the city public right-of-way on which
And
they front.
You said the Boston Street address it determines what is the front of your property line?
Light-offs?
That's correct.
Excuse me, I'm just gonna interrupt. Can you turn your flashlight off?
Are we being videoed?
We are.
Yes.
Oh. Okay. Let's see.
And just for the record, I'm sorry, Ms. Hecker, I don't mean to interrupt
No, you're
at
fine.
all.
I'm sorry I interrupted as well.
There's an exception to the Maryland Wiretapping, the Maryland Wiretap and Surveillance Act that allows videotaping and audio recording in public hearings. However, there's been many, many cases that say that you're supposed to get permission, or at least let the board know. Well, no one informed us, so just as a heads up,
For the
I'm
record,
sorry.
who are you and who did you ask permission?
I'm Salika Bazemore, I'm a Republican candidate running for mayor of Baltimore City.
And who did you ask?
So I got a personal invite up here to this particular meeting.
Who did you ask permission to video?
Well, security just told me they didn't tell me there was any rules about the video.
Oh, you just said that you got permission to video.
There was they said nothing, they let me I had my video on downstairs. They said nothing about me not being able to video. I was even on the fourth floor during the PGW hearing, and look, Councilmember Henry never have told me they can't video in an open public hearing.
No one's saying you can't video, ma'am.
So do I have the board's permission since this is an open public hearing? I'm gonna ask you guys, the board.
We will continue this hearing. All public meetings are open to the public. All public meetings may be recorded. However, there is a state agency that regulates this, and they have said multiple times that it is appropriate to give a courtesy to an agency to check in. Otherwise, you have things like a flashlight, which are disturbing the board members and disturbing. So with the chairman's permission, my apologies, Ms. Hecker, we can continue.
Permission granted.
So,
all right.
so they're going to continue taping, or they're not?
Yes, they are.
I don't recall if I said this or not, but we talked about the property having been subdivided into 5 lots for financing purposes. The overall site is providing about 1,000 parking spaces in total. Based on our calculations preliminarily, and again, some of this still has to be worked out with exactly who the retail users are going to be, but we think we're going to need about 710 parking spaces to meet the parking requirements across the board. So there's about 300 extra parking spaces across the whole site, and because, through shared parking and whatnot, that number may ultimately end up being reduced. So there is plenty of parking to serve all of the uses across the entire development parcel.
Are those parking calculations included in your submittal?
The parking calculations across the whole site are not, because we haven't exactly nailed down who all of our retail, whether they're retail or some type of personal service or restaurant type tenants, so that could change. But in rough numbers, I could give you a breakdown.
Okay, I only raise it because one of the letters we received from Harbor Enterprise Center had mentioned parking was a concern to them. So as long as the calculations have been done that a parking variance is not required, that would all, I just want to make sure that that's
Yes,
included
and
in the
again,
record.
as individual building permits come in for the individual buildings that we're proposing, we're going to have to demonstrate to the zoning administrator that we provide enough parking for each of the individual buildings with their proposed uses. But in total, in rough numbers, we have about 1,000 parking spaces, and by our math, we need about 710 parking spaces. So there's enough of a cushion there that I feel very confident saying that we provide plenty of parking to meet all of the parking requirements.
Okay.
All right, let's see. So with that, that I think for me covers the stuff that is consistent and common to all 4 cases. With your permission, I'll go into the individual cases unless we want to hear from the other side, but I don't think it's quite ripe for them yet. There are, as I said, there's 4 cases that are before the board for various variances that we need for the individual sites. So the first one is appeal number 2019-433. It's 3850 Boston Street. This is the Gray Star apartment building. It's an application for a front yard variance to construct a 500-unit multifamily building to permit the front yard to be set back in excess of the maximum 5-foot setback in the C2 zoning district. The site's just under 4 acres in size. And I would refer you, just for your reference, to Exhibit 18 in the file, which is our setback exhibit that identifies all of the proposed setbacks. This is the one that I mentioned before, that technically the closest point is within 5 feet of the front property line. It's 3.3 feet from the front line, right in this corner up here. But it does come back about 30 feet from the property line at its farthest point, which is intended to set it back to provide a sidewalk and landscaping and whatnot. As I mentioned, the site was subdivided pursuant to the Planning Commission's approval. The subdivision plan is included as Exhibit 6, and you can see some aerial images of this particular site as Exhibits 8 and 10 in the file. As I said, this is a 500-unit apartment building. It's going to be built over a 625-space parking garage. It has a significant parking component. The garage spaces in this building will be shared with the office building that's located south of this site. And because of the former oil operations on the refinery site as a whole, the parking has to be above grade. It can't be below grade because of the environmental concerns. There are also monitoring wells on this site, which I can refer you to Exhibit 12, that show the location of those monitoring wells. The building is designed around them so that they can be accessed and continue the monitoring from the environmental cleanup perspective. The main entrance faces Toon Street, which is here. And it faces this nice open space plaza right in front of the site. This project, the Gray Star project, went to the Urban Design and Architectural Advisory Panel in August, and I've included as Exhibit 19 in the file the plans that were submitted to UDAP for their approval. You'll see the elevations showing the proposed building, as well as some details of the landscaping.
Ms. Hecker, I apologize again. Ma'am, I can hear your conversation. If you need to have a conversation, please exit. Thank you.
Thank you. No. So as I mentioned, this is an application for a front yard variance to permit a front yard setback of 31.88 feet at its maximum distance from the front yard, where there is a maximum 5-foot setback permitted in the zoning code. The parking garage, as I mentioned, is above grade. It's being screened with a 4 to 5 foot planting wall and shrubs proposed along Toon Street. That drives some of the need for this building to be set back a little bit further to allow for that landscaping. And we also wanted this building to line up with to line up nicely across the front of Toon Street. We have this nice square plaza occurring in the front there. So we're trying to create a nice street frontage, and what's the word I'm looking for? The delivery trucks for the grocery store will also be coming in along Toon Street. So we need to make sure that that's a wide enough area for deliveries to occur. And obviously, we also are going to have a significant pedestrian component with the park that's located directly in the front. So we need to have enough space there to allow pedestrian circulation. Again, this site has been reviewed by the Urban Design and Architectural Advisory Panel, UDAP. They have determined that this is the appropriate legal siting for the building relative to the property lines that are created by the subdivision plan. And so I guess that's sort of the basis for that. I can go through the legal standards that I've proffered in the outlines that are included in the file if you'd like me to. I realize this is running longer than I thought it might, so maybe I'll move on. But yeah, maybe we'll move on to the next property at issue here, which is 2019-434. It's 3800 to 3824 Boston Street. This is the drive-through pad site, the signage for the grocery store, the setback for the drive-through. So we're talking about this parcel right here. And again, I would refer you to our setback exhibit, Exhibit 18, that shows the distances that are proposed We added a request for the signage variance after the application was filed. Just for the record, we had submitted a letter dated December 12th, 2019, which is in advance of the 15 days that is required to amend an application. So to the extent that you noticed that there was an addition of a signage variance, that's what that's about. So again, this property fronts on Boston Street. It's proposed to be consolidated with the right-of-way strip that runs along the front of the property, but which we don't own yet. And, you know, was subdivided as part of this subdivision that was approved in the fall by the Planning Commission. The site as a whole is proposed to include the grocery store, which is a Sprouts, the bank pad site. It also includes the park, as well as also part of this parcel, which is here. We are proposing the large parking field along the Boston Street frontage because of the location of the monitoring wells and the tunnel that comes under Boston Street that we have to leave in place for a while. We also need to provide significant streetscaping along Boston Street. We're keeping a 15.5-foot planting strip along Boston Street, which is along here, followed by an 8-foot sidewalk, followed by another 15-foot planting strip along the front of the property. And then, as I had mentioned before,
Can I ask a quick question?
Yeah.
That triangle includes the city property, right?
the property line runs like about here.
Okay,
It
so
runs
it's
right
halfway
below
through the
retail.
hotel.
Yes, it runs halfway
Okay.
through the hotel, that's correct.
Thank you.
Yes. Let's see. So as I mentioned, the grocery store is Sprouts. It is about 30,000 square feet here. There's also a little over 12,000 square foot retail building that'll be adjacent to it. I've included in the file the Urban Design and Architectural Advisory approval of the signage for Sprouts, as well as an article about the Sprouts Farmers Market coming to the Canton project. They're based in Phoenix. This will be their first store in Baltimore City. They focus on organic, gluten-free, health-conscious offerings. They have a big prepared food section, and one of their other closely located stores in Ellicott City hired 140 full and part-time employees. We expect that it will be similar at this location. It's a great job creator for this part of the city. The pad site, as I mentioned, is a bank that'll have 2 drive-through lanes that have been relocated to the south side of the building at the request of the Urban Design and Architectural Advisory Panel. Initially, we had the drive-through lanes on the side of the property, of the side of the bank, which would have allowed the bank to sit a little closer to the property line, which again is one of the variances that we're requesting, is to shift the bank back more than 5 feet, which is what's required from the front property line. UDAP, the Urban Design and Architectural Advisory Panel, required us to move the drive-through lanes around the south side of the building, and as a result, we had to push it farther back. That's what's driving that need for the variance there. And let's see, with regard to the signage variances that are requested, Exhibit 20 in the file shows the signs that have been reviewed and approved by the Urban Design and Architectural Advisory Panel. We're requesting approval of a freestanding sign with a height of 29 feet and an area of 151 square feet. The maximum permitted sign would be 6 feet high and have a maximum area of 16 feet. That obviously contemplates a much smaller site. I think this is another instance of the C2 regulations not contemplating the redevelopment of a very large site with a building that's going to be set back significantly from the major right-of-way. In addition to the freestanding monument sign, we have a wall sign that's proposed. Interestingly, the way the new zoning code talks about measuring the size of a sign when the sign is on a background, it provides that for signs on a background, the entire area of the framework or background of the sign is calculated as the sign area. I'm quoting from section 17302 of the zoning code, which is also in the file. So we're required to include any material or color forming the sign face or background used to differentiate the sign from the structure against which it is placed. And you'll see in the rendering of what the sign's going to look like, it has this wood background, and as a result, we have to calculate the entire size of the wood background as part of the sign that's being approved. So this results in a sign that's 583 square feet. Under the zoning code, the maximum sign area.
Is this what you're talking about?
That's it, yes.
So this is theoretically a facade and not a sign with just letters on it?
No, it's the reverse, actually. Under the zoning code now, that's how it used to be. Now they treat the whole thing, all of the brown, as a sign. So we have to count, it's a big sign, right? It's a 500 and, what did I say, 83 square foot sign. It sounds enormous, but it isn't really. I mean, what we really have are some small letters in some different places, but because of the methodology under the current zoning code, we are required to count the whole thing. So that obviously triggered a need for a variance. And again, this is maybe a good example for us of a case where, you know, we're in for permits for the Sprouts building. Like, we need to get a permit for the Sprouts building. We know we need a sign variance. And so that's why this is included as part of our application today. And as we go forward with the other buildings, if it turns out we need a variance for something related to a setback on another building, we certainly will apply for one. But this is, you know, here we are with the Sprouts. It's under construction. We are working on our signage plan. This is the sign that we've landed on with in consultation with the Urban Design and Architectural Advisory Panel, but based on the way that the city calculates wall signs, including the background of the sign, it comes out to be a much bigger sign than what we would otherwise approve. So,
is it actually going to be wood with letters on it? Is that?
I think it's a composite. I don't think it's wood, but it will look like wood.
The letters like stand out, right? Like they come
They're
forward a little bit.
projecting from the face of the sign. That's right. Yeah.
They sprout.
Beg your pardon? They sprout.
No.
Yes. Yes.
Just saying.
You couldn't resist that.
The door right open.
Yes. All right, let's see. So I guess the only other thing I would mention on that is that the signs are consistent with the signs that were previously approved for the shopping center directly across the street. They're not out of character or inconsistent with other signs that have been approved in the vicinity of the project and in other C2 zone properties. Okay, that's what I've got on the signage variances, or that Sprouts parcel. Oh, I'm sorry, yes, you're absolutely right. The drive-through is a conditional use for the bank, and the legal standards are set forth in the outline that you've got in front of you, but the general standard for a conditional use, as we all know, is that the inherent adverse effects of the use are no worse at this location than they otherwise would be. A pad site at a shopping center is clearly the right place to have a drive-through for a bank. There's a bank drive-through across the street in the shopping center, the shops at Canton Crossing. It's been very successful. It has not created any adverse impacts, and we don't expect there would be any adverse impacts created by a drive-through at this location on this site. You know, again, the conditional uses are presumptively allowed, absent some finding that the inherent adverse effects of the use are worse at this location than they otherwise would be.
What's the bank at Canton Crossing?
TD Bank, and there's and BB&T also, yeah. So
Still open.
Still open. That's right. All right, so let's see. Next, I have the 2019 435, which is 3900 to 3902 Boston Street. This is the hotel property. And again, I would refer you to the front yard exhibit. That's exhibit 18 in the file. The proposed hotel is going to be about 21 feet off of the front property line. That's to allow for the landscaping strip, the sidewalk, and the additional landscaping in front of the building. Again, this is an instance where the C2 zoning regulations really create the practical difficulty, because I don't think anyone wants to see a hotel within 5 feet of Boston Street. I mean, that it needs to be set back. And because I know someone's going to ask this question, this is half located on property that we don't currently own. We absolutely recognize that we cannot build a building on this property unless and until we own it. The reason that we're applying for the variance for this property today is because we're here anyway. The pad site has been identified by the Urban Design and Architectural Advisory Panel already, so we know where the building footprint is going to go. And so we included this as a variance request, since we were going to be applying anyway to the board for the other setback variances. The basis for this variance is the same as the basis for the other variances, in that the C2 regulations really don't contemplate the redevelopment of a major site like this. They really address infill development within existing city blocks. So let's see. So the hotel, as I mentioned, was part of the UDART master plan approval. And I talked about the landscaping strip and the sidewalk and the additional landscaping strip as well. As I mentioned, we're removing the utilities, the above grade utilities along Haven Street. This is really going to be a very nice entranceway into the property, into Southeast Baltimore. We will have to go back to the Urban Design and Architectural Advisory Panel for the final design of the hotel once we've identified a flag for the hotel. It's very preliminary, as I mentioned, that we can't build the hotel until we acquire the city property. So that is a future phase of the project, but we would like to have the approvals lined up at this point so that we can move forward. Again, we were requesting a 21.1 foot setback from Boston Street in lieu of the maximum permitted 5 feet. And again, the setback variance standards are included in the outline that I've submitted in the file as well. And then the last one that we've got is the office building, which is a heavy timber office building, which is unique for Baltimore. It's a really exciting design. That, as I talked about, is here. We are requesting a setback. It will ultimately, when we acquire the city right-of-way parcel, it will ultimately be 252 feet from the front property line. So this is going to be a long distance from Boston Street. It's much more than the 5 feet that's proposed, but because it has a Boston Street address, that's where we have to measure it. The setback exhibit, again, is Exhibit 18. You've seen the subdivision plan. Exhibit 24 in the file shows the UDAP, Urban Design and Architectural Advisory Panel presentation that was made on the proposed building. It's a really cool-looking building using heavy timber construction. And the reason that we've cited it in this location is so that it can really follow the same line across from the other retail building to square off this park in the center here. It really, I think, would look a little off kilter if it wasn't lined up with the grocery store, and that was part of our site design. And that, again, has gone through the master planning process approval with the Urban Design and Architectural Advisory Panel, the City Site Plan Review Committee. And the direction from the city that we have been given is that this is the appropriate location for this building. And as a result, as I said, the C2 regulations just don't contemplate this type of large-scale redevelopment and create this practical difficulty for us. I realize I'm talking quickly. I think that gets us to the end of what I wanted to cover proactively. Mr. Kraft is here. He would be an expert who would testify as an expert in site design and land planning. We're happy to have him testify, answer any questions the board might have about the particular locations of the buildings, why we've put things where we've put them, the location, and proposals for cross-access easements across the properties and whatnot. We can certainly have him testify, and the developers here as well if there are any questions that the board has for him.
Any questions, board?
Good presentation.
Thank you. Thank you. Now, this is being opposed, correct? Yes. Time out. We need to take another small break.
Very small.
Super small.
Sorry, I was trying to make
There you
it,
go.
but I can't.
Yeah.
Perfect.
Have everyone?
Yep.
Okay, thank you for the opportunity to speak. I'm going to try and be a little bit briefer than Caroline, but it is going to take a little bit to get through this. I did have a handout that all of you have, which is the basis for our objection to the variances of the 5 foot.
I thought these were all mine.
5 foot front setbacks. One thing I'm a little bit unclear of, the only thing I was aware of was the 5 foot front setbacks and the conditional use for the drive-through. I wasn't aware, didn't see anywhere in the application, maybe I missed it, about the signage. I don't know why was that part of the application? Because we didn't get a copy of any signage.
Yes or no? Problem with the sign, yes.
I haven't seen them. I haven't seen them.
Okay. It's a big sign that says Sprouts. So it's big.
I didn't know if it's one sign or all the signs packaged, because some of the drawings.
Hard stop at 5:30, so we absolutely appreciate that you're in opposition and you're welcome to testify about that, but we need to move on with things. So
I understand.
Problem with the sign, not a problem. You're welcome to testify. If you don't have a problem with the sign, I would really appreciate it if we would move on.
I haven't seen it yet. That's all I'm saying.
Fair enough.
Okay. So when all is said and done, this project is going to seek a front and rear, all over the campus here. Front setbacks, rear setback variances, signage variances. It's already received a height variance, yard variances, parking variances, et cetera. Why? Because it's in the C2 zone, and our development is not compatible with the C2 zone, so we need all these variances. That's the basis for the argument. So This was a C2 property when they bought it. They knew what it was when they bought it. It wasn't a surprise when they bought it. Let's go through all these variances one by one. So building one, the apartment building, 500 units, the front setback, per their original application, was a 21-foot setback off the front, in excess of the 5 feet that is allowed per zoning code. It is measured to a newly created Toon Street. It's not measured to an existing road that they cannot move. Building 2, the office building, the front setback is 22 feet right here, again to the south, in excess of the 5-foot minimum. None of the 4 sides, in fact, are within the 5 feet of the property line.
I understand for the apartment building why there's an argument that you're negatively impacted, but how are you negatively impacted by the setbacks asked for within the actual site that aren't anywhere near your property line?
Can I go through the whole thing? And she was able to go uninterrupted. Can I go through my presentation?
And I interrupt her all the time.
Okay, I will get to that, I promise. Building 3, the hotel down here, the front setback is 21 feet in excess of the 5-foot minimum. It is measured to the lot line of the city right-of-way, which is, I gather, right down here, the hotel, on Boston Street. Again, none of the 4 sides are within the 5-foot lot line, regardless of which is the front. The bank pad site, the setback is measured to this lot line, I believe, which is the existing city lot line, which is going to go away. So when they merge the locations, then that goes away, and then this becomes the, ultimately, the front setback is considerably longer, much like closer to 60 feet. All right, so the variances requested on page 3 of the PowerPoint are on these 4 buildings, 1, 2, 3, and 4. The reason given for the needed variances, the reason given in their application was to accommodate internal pedestrian and motor vehicle circulation, as well as monitoring wells installed in connection with remediation of the former Exxon refinery. The buildings exceed the maximum permitted front yard setback of 5 feet, and thus variances are requested. Sounds perfectly reasonable. Okay, in general, so the overarching view of variances is that they are not intended to be a substitute for a PUD. If you buy a large C2 property and it doesn't work for the type of development you want to do, then you do what we did, and you do what Canton Crossing did, and you go through the PUD process. The PUD process engages the community. You have charrettes. You go back and forth. You get approval from the neighborhood for specifics like signage, for specifics like height, for specifics like setback and circulation, and so on. We did not go through the PUD process here. Rather, he's trying to use the variance process in a C2 to accomplish the same thing. The problem is that that's not the appropriate way to engage the community and to engage us as the neighbors immediately next door who are harmed by some of the deviation from the design intent within the zoning code. And I'll get more into detail in that in a second. So without a PUD, the neighbors are forced to rely on the zoning code to ensure good urban design and that they are not harmed. Variances to zoning code are therefore intended to be very difficult to obtain, are not given out lightly, and are only granted if they meet strict legal standards for specific, well-documented cases.
Are you reading from the code there?
No, I'm not, but I will in a second.
Opinion.
No, that's my lawyer's opinion. Yeah.
I said it's your opinion.
Yes. So the question is, do the reasons given for the variances meet the city's strict legal requirements? Caroline glossed over them. She skipped the city's strict legal requirements. So I want to go through them because I contend that they do, not only do they not meet the strict criteria for variance, but the reasons given are explicitly quoted as reasons that don't warrant a variance. Okay? So there are 2 parts to this. One is it doesn't meet the criteria. The other is the reasons they gave are specifically named as things that don't qualify for a variance. All right, so page 6 of my PowerPoint. What are the city and the state's strict legal standard requirements? And this is quoting from the code. If a strict letter of the applicable requirement creates an unnecessary hardship or a practical difficulty, as opposed to a mere inconvenience or a desire. Now, that is in parenthetical, that's not in the code, or desire is not in. And it has to be both conditions, and it is due to a particular physical surrounding, shape, or topo conditions, i.e. the uniqueness of the site, what makes it different from the neighbors. Then a variance may be granted. So do we have these two conditions here? Do we have the practical difficulty and the uniqueness? So unnecessary hardship is actually not applicable under Maryland law. So the standard is practical difficulty as opposed to unnecessary hardship is the correct standard under Maryland law for an area variance. It really doesn't matter whether you use unnecessary hardship or practical difficulty because neither standard is met anyway. But practical difficulty is the legal standard. What is practical difficulty? Practical difficulty is the need that is sufficient to justify the variance. It must be substantial, and it must be urgent, and not merely for the convenience of the applicant. Not merely for the convenience of the applicant. In other words, you cannot just desire it. You can't just say, I want it, and therefore I'm entitled to it because this is a big project. We're going to have nice food at Sprouts. You know, those things are irrelevant for whether or not it meets the legal standard. So, the practical test. There is a 3-part test for whether it meets the practical standard in the zoning code. Montgomery County versus Rotwein, 2006. Whether compliance with the strict letter of the law would unreasonably prevent the owner from using the property for a permitted purpose or would render conformity with such restrictions unnecessarily burdensome. What is the unnecessarily burdensome problem that they have here? How are they burdened by the zoning code? Why can't they comply? We can comply. We complied up here. We did a PUD. And even with the PUD, we still complied with the spirit and design intent. We built right up to the property lines. You know, we have a dense urban development. Some of this is historic, but then even in the new ones, we did exactly what the spirit and the intent of the zoning code desires. What we're getting next to us is a suburban-style York Road Timonium shopping center. That does not meet the intent of the code.
Are there ever any variances sought and obtained in a PUD?
You negotiate the PUD up front. And that's what we contend that they should be doing. It says everything is negotiated up front. And if we were to deviate from what's negotiated in the PUD, then you have to do an amendment to the PUD. So it's a very rigorous process that we went through and that what Mark went through, you know, over on Canton Crossing to the south.
There's no legal requirement that they have to get a PUD.
There's no legal requirement, but you're absolutely right.
And as a part of the PUD you negotiated, I'm assuming certain variances were negotiated up front.
Almost de facto, sort of.
Yeah.
But everything is negotiated. Yeah, absolutely.
What would have you done with the property if Exxon had sold it to you?
We actually had full-blown plans that were very dense here, which I didn't bring with me, but we had, you know, we did not have.
Did it involve variances?
No, because we had, well, we didn't get that far. We didn't buy it. But we had a, you know, urban street grid that went through here, and we were building to the corners for everything. So we have this dense environment from here all the way to downtown. Now all of a sudden we're shifting the urban design into something completely different without any input from the neighbors in terms of what do you think here?
I'm close to the point where I want to hear from you, and I understand, and please feel free to go back to your PowerPoint, but I really want to hear how you're aggrieved by the variances requested that don't have anything to do with the property line. I obviously understand the property line issues because you testified to them during the negative appeal. And I thought you did a nice job laying that out. I don't understand how the rest of it impacts you. I understand what the law is. You don't have to, I mean, I sit on this board, I read the law, I know what the law is. I'm just wondering, now I'm asking you a specific question.
Right. When we were starting this project back in 2000, we met with Senator Barbara Mikulski, and we went through everything that we were looking at doing here. And the one thing she said was, whatever you do, don't make this York Road.
Okay, but that.
And I'm getting.
Are you about to tell me that you're aggrieved because you think this looks like White Marsh or York Road?
I'm suggesting that the surrounding property values are diminished when urban standards, as dictated by the zoning code, are not met, and that the purpose.
This is a property that went to UDAP, and UDAP worked with them to come up with something that worked.
Right, and UDAP did not hear what we had to say. So UDAP was only looking at it from the city's interest and working with them. The community never got any input whatsoever in terms of, I can't think of one change that was made to this as a result of a community input in the
But
property.
the issue is, and I understand, I do understand what you're saying, because I live in Baltimore, obviously, and I care about the historic neighborhoods and that they look a certain way. But the difference is this was a industrial site that oil wells were on. This wasn't the historic site that your PUD is a part of, that has historic buildings that were a part, it looks like part of, that have been there for a very long time. So that would require some sort of like stricter protection, because there were historic buildings. This is an environmental hazard that's being cleaned up and
See, this is Caroline's exhibit. This property up here was owned by Exxon. That's now this right here. This was the exact same Exxon refinery we had here. Same monitoring wells, maybe not as many.
All of those
There were
buildings are
tanks
new?
all up here.
Okay,
Okay? This was the historic brewery over here.
okay.
What are those two buildings?
This is the Porter Brewers Hill, and we're building right here, right now, all the way to the lot line.
Right now, there's a new building.
Right. So,
That kind of looks like a county all over the wall.
so in terms of, if I could continue, and some of these questions I'll get to as I proceed. The variances do not meet any of the three-part test of practical difficulty. There is no unnecessary burden. There is no substantial justice matter, and no relaxation of code is necessary to get the full benefit of the property. The spirit, and this is really the crux of the urban design, is just not observed here. So before you even get to practical difficulty, you have to look at the uniqueness of the site. What have they suggested is unique about this site?
But even if we denied their variances, the buildings look like what they look like, and we can't control that. Like, they've already been approved, like, that is what it is. So even if I said, you have to move your building, it can't be this close to that new street or whatever, the building is what it is. It's still gonna look like what their plans are. Zoning board can't fix that for you.
I'm not suggesting that
It just doesn't, I don't know, I'm wondering if we can give you, I don't know that we can give you the relief that you're seeking. Like, it doesn't, it sounds like you want these buildings to look historic, and
No.
that's why you're upset.
That's not what I'm saying at all. I didn't say they have to look historic. I said they have to have the urban design. There's a design code in the design standards. In a C2 district, off-street parking is prohibited in the front building line and must be screened from view from the public right-of-way. In the zoning code, in a C2 district, here it is, right here. They're not complying with that in a C2 district. Have they asked for a variance for that? No. So they've bought a C2 property, and now they want to be able to circumvent all of the restrictions of that C2 property by going through a variance rather than the proper procedure of going through a PUD. That's what our objection is. And it's nothing to do with making them look historic. I don't want to have a false history.
But we can't make them go through a PUD either. They aren't legally required to do it, so.
No, but I believe they're seeking relief, correct? They're asking for a variance from the code, and we're simply asking that the code be upheld,
Understood.
right?
Yeah, that's all we want is the code to be followed.
Okay.
And however they want to do it is up to them. And there are lots of solutions, easy solutions, that result in a better project that enables them to enjoy the full benefit of their property.
But you do understand there's some subjectivity to this. It isn't a black and white situation. It isn't you say it's black, they say it's white. There's a huge area of gray here.
Sure.
And you're a developer, so I'm confident that you have played in the gray area as well.
We've never sought a variance for anything.
Other than the PUD you
The
negotiated.
PUD is, yes, if they want to do a PUD, great. Absolutely. We encourage them to do a PUD.
Okay, well, I think
That's the point.
You would like a PUD.
Yes. So in order to qualify, again, the property has to be unique. If it's not unique, then it doesn't qualify for a variance. So if the property is unique and unusual in a manner different from the nature of the surrounding properties, not because it's a C2 property and it's a triangle, that has nothing to do with it. Is it different from the surrounding properties? It's not different environmentally. The triangle, this was a triangle, which we did here. It's no different than that triangle. The shape of the property is not dictating the need for the variances here. It's a completely unrelated topic. So there must be a connection between the uniqueness of the property and the variance being sought, and that does not exist here. There is nothing unique that they have mentioned that is different than what we've dealt with or what's been dealt with in other C2 properties around the city. So why the variances should be denied? The variances are impermissible because the stated reason for the variance, the monitoring wells and the circulation, do not even impact the front setbacks that they're seeking relief from. And therefore the solution, there is no solution, i.e. a variance, is even required to get relief from the monitoring wells. Even if the wells were impacting the front setback, they can very inexpensively be relocated. We looked at this site, we looked at buying it, we looked at the cost of relocating. It was about $20,000 to move them a little bit. That's not a material, on a $200 million project, that's not a material expense. The applicants provided no documentation that the wells impact the front setbacks. They just said there are a lot of wells and we had to design around them. Well, I'll demonstrate here for a second. The variances therefore solve no problems related to the issues that they've brought up that they purport are being solved. So page 13 shows where the monitoring wells are. This is their drawing. This isn't my drawing. This is their drawing. First off, only one of the 4 buildings even has a monitoring well on it. This is the major reason they've put forth for the variance, that they have monitoring wells that they have to design the buildings around. Only lot 2 has a monitoring well on it that they're seeking a variance for. So where does that logic come from? Lot 1 doesn't have monitoring wells on it. Lot 3 doesn't have monitoring wells on it. The retail bank doesn't have any monitoring wells on it, unless their exhibit is incorrect, and then I'll stand corrected. So first off, only one of the 4 buildings needs relief from a monitoring well, and that relief is not even on the front, it's on the side. Right? So look at lot 2, the office building. They have 2 monitoring wells. They're on the right and left of the office building. The front is the south, the lower side. There's no monitoring well there. Okay? So none of the buildings have wells on the front side of any building where the front setback relief from the wells is being requested. 3 of the lots don't even have wells on them. Second issue, they've cited circulation. Internal circulation is not impacted by the buildings located within the lots. It does not impact the building circulation. The building circulation or internal circulation, pedestrian or vehicular. You can move the building around just as we do in any urban setting. You can move the building around within the lot, and that doesn't impact the setting. The roads aren't going to change. The sidewalks may be, slightly different size or shape, but the design code is clear what they want in terms of pedestrian sidewalks and the depth from the front of the property. And there's reason for that in the code. Internal circulation, furthermore, all right, so there is no uniqueness. I'm on 15 now. Even if there is a uniqueness, there's no connection between the alleged uniqueness cited, the monitoring wells, and the variances requested. None of the wells have any impact on whatsoever. This I've already said, so we'll go to the next one. 16. The applicant has not demonstrated the variances requested are the minimum amount necessary required to accommodate the monitoring wells or accommodate any purported problem that they may come up with. Is it the minimum amount that you're doing to account for the alleged problem or uniqueness? No justification is given why some of the setbacks are 20 feet, 30 feet, 60 feet. That's not a minimum. They're not moving the building the minimum amount to do it. They're moving it to put it wherever the heck they want. And now they're alleging that they're aggrieved, and therefore they have to seek these variances. There's a question of ripeness here, too. The lot lines are not determined yet because the final consolidation, this lot line is going to go away. So which lot line are you even measuring to? How do you present and request a variance to a lot line that may or may not exist? So any of the properties that are seeking front setback variances to lot lines that may disappear, we're not ready then to hear those variances. When they get the building finalized, when they get the lot lines finalized, when they've bought the property, that's the appropriate time to look at it. The applicant has not demonstrated that the application of the strict letter of the law creates any practical difficulty as opposed to a mere inconvenience. Mere inconvenience is defined in the code which is not sufficient for granting a variance, includes arguments related to property value and improved site circulation. So improved site circulation is specifically named in the code as a reason that you cannot grant a variance. Yet that's the reason that they've given for the need for the variance. The setbacks simply do not impact circulation anyway. So the two reasons given to justify the variances do not meet the strict legal standards. Even a liberal reading of the standards, even a subjective reading of the standards, it doesn't rise to the level of a need. There's nothing unique. There's no burden. They haven't tried the minimum way to approach it. They're violating urban design. Perhaps the most important thing that will invalidate a variance is whether it is self-created. If a variance is self-created, if you created the problem to begin with, as opposed to something inherent in the property that you didn't control, you can't then seek a variance from a self-created problem. That is in the code. So the zoning code requires, it mandates, in other words, a finding that the variance request is not due to the intentional action or inaction of a person with a present interest in the property. It mandates that if it's their fault, they can't get a variance for it. There's no subjectivity there. That is the code, that is the law. These variants are being requested in connection with the applicant's subdivision, which created new lot lines, and the applicant's desired building location within those new lots, which he alone determined. He started with a blank slate here, a beautiful 12-acre blank slate. Then he drew the lot lines and said, oh, I need a variance from my own lot lines. That's specifically prohibited in the code. The front setbacks are measured from newly created lot lines that are entirely of his creation. The applicant can easily reposition the buildings, enlarge the buildings within the lots to comply with urban design standards. If the wells were in fact in the way, the applicant could easily relocate them at minimal expense. But as we've demonstrated, the lots aren't even on the lots. The wells aren't even on the lots, and they're not in the front. So, in summary, none of the city and state's strict legal standards, not one for granting a variance, is met. There's no uniqueness, nothing different from our site. There's no practical difficulty. There's no urgent need. And it violates the city's design standards and spirit of the zoning ordinance, which is intended to protect the neighbors and the general public around the area. That's why you have a zoning code. That's the whole reason why you have the code. Otherwise, just throw the code out. If you're going to grant a variance for everything that any developer wants, what's the point of a zoning code? The reasons that the legal standards for why they must be denied have been met because it is a self-inflicted problem. The reasons given in the application are false and incorrect to begin with. The oil wells are not impacting the setbacks in any way. The internal circulation is not an allowable reason by code, and it's not impacted by the setbacks regardless. All variances requested, if there were an actual hardship, are a result of self-inflicted design and not inherent unique site problems. The applicant has not identified the final consolidated lot lines for several of these lots, and setbacks are measured from the incorrect and presently unknowable final lot lines. Furthermore, all setbacks can be corrected by following proper C2 urban design standards. Follow the spirit of the zoning code. If the desire is just a more profitable site plan, the zoning code is intended to protect neighbors from poor urban design. We are totally in favor of development. Don't get me wrong. We are totally in favor of development. We just want to see it done right and done in a way that the zoning code is meant to uphold. So that what should, in our view, happen is the applicant should first establish site control for the city lots, determine the correct and final lot lines. Don't pick an intermediate lot line and say, okay, I need a variance from this, knowing that that intermediate lot line is going to go away. You can't pick one configuration for a rear setback and then another one for parking. You have to use the same lot lines for everything you're seeking. You can't cherry pick lot lines to suit what you want just because that's how you circumvent the zoning code. And that's what's happening here. It's an end run around the zoning code. They need to correctly identify the front lot lines. Then 4, go through, in our view, the PUD process and engage the full community in a more comprehensive, deliberative, and meaningful manner that gives the neighborhood, the abutting property owners, the surrounding community, the say that they're entitled to, that they had when I did my PUD, and that they had when they did this PUD for Canton Crossing. Variances are not a legal substitute for a PUD. We have letters from the community associations who say that they are asking you to uphold the strict legal standards in the zoning code. What they're saying is, don't just start granting variances for everything. They've asked for setback variances, signage variances, height variances, yard variances, parking variances.
Are you saying we have letters in this situation?
No, we don't have letters, but it's the same language for over here. It's the same language for this, right? Saying, uphold the code, otherwise we're going to be damaged. Thank you.
Thank you.
I still don't understand how this would adversely affect Joe. That's what I asked right up front.
Okay.
I mean, are you like the protector of the city in the process, or does this adversely affect Joe?
No, we think everything adversely affects. We think if it was done right, it wouldn't adversely affect us. But we don't think it's being done right. We don't think they're following the zoning code. We don't think they're following the design intent that's in the zoning code. And we're stuck now with the backsides of their loading areas. We got to look at their backsides here. We're stuck with an alleged 0 setback here, although we're going to contest it. So we're giving up our rights here. So, I mean, I can go on and on. We're stuck with parking that isn't met here, so they're going to flood into the neighborhood. There are so many issues that they're seeking variances for that we've had enough. And it's time to say, you should have gone through a PUD. It's not too late to go through a PUD. Let's fix this before everything is built.
Would your argument change if they went through a PUD and they were given and they present this exact same plan?
If we had the opportunity to meet with the land use committee and we presented that what we thought was a better design and they ought to tweak this and so on, and at least one of our concerns was listening to, we would feel a lot better.
What if none of your concerns were listened to and it's the same exact thing and they
then I'm
go
stuck.
through a PUD
Then
and it's approved?
Right, then I'm stuck.
Okay.
That's absolutely right.
So your gripe is with the process then, not necessarily with this design?
No, not necessarily. My gripe's with the design, and I want to have the process as a way to fix the design in a way that doesn't harm me any further. If it was done the right way, there would have been a process in which we would have had some input. The same way we had charrettes when we did our PUD here. We had charrettes with the community. We changed our plans based on what the community said. We changed our parking counts based on what the community said. We changed our signage based on what the community said. There is no community input here. The whole point of the PUD is to enable. That's why we're aggrieved. Otherwise, why have PUDs? It's because it gives the opportunity to the neighbors to participate.
To be fair, the point of posting and giving notice of a hearing is for opposition to show up if you have any opposition. So we recognize and note that there's no community opposition to these particular requests. But at this point, let's hear from Ms. Hecker in response.
I know we're running short on time, so.
I'm gonna say 3 things. Can you address the lot lines, why you think there's a practical difficulty and uniqueness?
Yeah.
Yes.
Thank you. I wrote that down too.
Yes. With regard to the lot lines, there is absolutely no requirement in the zoning code that an applicant for a variance have ownership of a particular property. In fact, this board hears applications all the time from contract purchasers for pieces of property during their due diligence periods when they're underway with the beginnings of a project. They get a property under contract, they apply to the board to see if they can get the relief that they need to do whatever they want to do with the property. And as long as the owner of the property has consented to the application and doesn't object to the board granting whatever the relief it is, there's no requirement that the property owner be the applicant for the variance or that the applicant own all of the subject property that the board is granting the variance for. So there's no requirement that we own the city parcels that are part of the right-of-way right now in order for this board to approve the requested variances. On the uniqueness front, the general legal standard for approving variances is that the property is unique and that the uniqueness creates a practical difficulty based on the way that the specific zoning regulations impact the site. We've put on a lot of evidence about why the properties are unique. I would draw your attention to exhibit number 12 in the file, which is the monitoring wells plan, which is a more complete version than the one that was presented to you a moment ago. It shows the locations of all of the wells. You'll see they are scattered throughout the center and east side of the site. They are part of what, but not the only thing that is driving the need for the variances. Excuse me. In addition to the locations of the monitoring wells, we have irregularly shaped parcels. And we have these conflicting regulations and conflicting desires on the part of the city, particularly the city's Urban Design and Architectural Advisory Panel, which is a group of architects that are engaged by the city, private architects, who review design plans for major construction projects such as this. And one of their priorities is creating pedestrian access, which is distinct from pedestrian circulation. If you were to have the building set back no more than 5 feet from the property lines, you would only, at an absolute maximum, be able to have a 5-foot sidewalk, which is not nearly enough, wide enough to have an adequate sidewalk. The city standards require 6 feet. So you would have to have the building setback even, I mean, at a minimum, a 1-foot variance beyond that 5 feet to allow the creation of a sidewalk. Again, the practical difficulty here is created by the application of the city's zoning regulations in the C2 district that don't contemplate the creation of new streets and sidewalks and spaces that are traditionally owned by the public, owned by the city. Typically, you would have a piece of property that fronts on a right-of-way, and at the property line, in front of the property line is where you have the sidewalk and the landscaping and all of that. Here, you have a property line that is, you have to create those things, the sidewalk and the landscaping, on the inside of the property line, and that's why you have to set the building back a little bit farther than you otherwise would do. Again, the design of this site, the master plan for this site, has gone through extensive review by the Urban Design and Architectural Advisory Panel. I'm trying to say that over and over again rather than using the acronym.
I've memorized it now.
Okay, good. And they.
Is that a hallmark of, I guess, best practices, or in light of, certainly UDAP should know what the zoning code says?
Absolutely, and they have a series of design guidelines, which is what Mr. Obecht was referring to a moment ago. Those are not codified in the zoning code, they're guidelines, and the design panel reviews those when they review these projects, and they determine whether in a particular instance they're applicable or appropriate or should be implemented. Obviously, in this case, the one that was raised was regarding the screening of parking, and the comment was made about the setback from Boston Street for the Sprouts building. But if you look at the site plan, you'll see that there's an extensive row of like 2 rows of landscaping with a large sidewalk that goes in between, and that serves the goal that's established in those design guidelines of screening the parking area from the public right-of-way. It doesn't have to be done by putting the parking behind the building. The parking can be screened through landscaping and setbacks, and that's what the design panel has reviewed and ultimately approved. I don't, to the extent it's self-created, the argument was that it was self-created. I can point you to the Chesapeake Bay Foundation versus DCW Dutch Ship Island case, which is 439 Maryland 588. In that case, the Court of Appeals held that the self-created hardship relates to the uniqueness of the site. It can only be a self-created hardship if the thing that is making the property unique is what was created by the applicant, not the practical difficulty. The practical difficulty here is due to the application of the zoning regulations. We didn't do anything to create the uniqueness. The monitoring wells are established at their locations under a consent agreement with MDE that was set back in the late 90s. And they have to be there for particular reasons. I see Mr. Saperstein lurking over here.
Just a very quick question with
Yes.
regard to the monitoring wells. Are there any particular, I imagine there are, particular requirements or ways to access the monitoring wells or space around the monitoring wells?
Absolutely, they have to be,
If I could just talk, and I'll make it brief because respectful of everybody's time. Just a couple more facts. There are 17 monitoring wells still left on the property. It won't be closed out between now and 2034. That adds to all of the uniqueness as to why the buildings are where they are and designed the way they're designed. To answer your question specifically, yes, there's a certain amount of property that you need around that, so when Exxon comes in to check on these wells, and we're constantly monitoring them and doing the work that's under the consent decree. Yes, there is an area that you have to leave around the wells. We still have 2 wells across the street in our other project that we have cones around so that people that are maybe at Nordstrom, you know, if there was an emergency, they could get into those wells. So I'm very familiar with why the buildings are designed the way they are, and that was explained to the planning department all along, that if this was going to proceed, this is the only way it could really proceed. And it was something that was there on site when I bought the site, so I didn't create that. To get into these costs, and I want to make this another very brief comment. When you talk about how inexpensive it is to move a well, I put $4.5 million in escrow account to just finish cleaning what's on site when I bought the property. So it's not an inexpensive proposition. Exxon has that across the street on the industrial piece on the east side of Haven. They have their main system and everything drains over through that where it's emptied out, et cetera, where these wells are basically drawing down oil until they're clean. MDE comes out, they check them, and then they get closed out. So it's a long process that I agreed to take on with, you know, the Department of the Environment and everybody else through the statement, signed, what, a 300-page document, put the money in escrow. I know exactly what's going on that site at all points. So I just want to be clear, it's not an inexpensive proposition. We didn't make it what it was. We're working around what it is accordingly. So I just want to be clear that this is not something I threw out there.
Guys, how much longer? Because I have a hard stop at 5:30, and I want to be able to deliberate on everything today.
I think do we have anything else you want to add? I think
Other than
we can wrap
10
up.
meetings I've had with the community,
Oh,
other
yeah.
than that, we're good.
We've met extensively with the
Extensively.
community. They've had extensive input into the proposed design.
Yeah,
And,
So the community had input into the design.
absolutely. And we heard from them as recently as yesterday that they have no objection to us going forward with the variances.
Is that
today.
why no one's here?
And that's why no one's here. Yes.
Okay.
Thank you for your presentation.
Thank you.
Thank you, guys.
That will conclude it.
Ready for deliberations?
We'll vote on this one first. Do we vote on this one first?
Off the record, I assume, yeah?
Yes, sir. Thank you.
Record 5:30.
Do you guys mind if I eat my apple?
No, not at all.
Rewind what?
Dig in.
I'm like,
Rewind what?
Yeah, I know.
Obviously, these wells don't.
I'm good. Actually, let me see that.
Oh, shit, there are food? Oh.
All these are under the building.
Oh, wow.
Their exhibit.